Good morning, all.
Good morning.
Good morning.
Morning. Sorry, Tando, we've now already muted all of the attendees, and I was actually just asking if maybe we could open the chat or the Q&A just to get people to say morning.
Okay, fine.
Yeah,
Super.
but it's all right. How are you?
Sure. Not bad, you.
I'm all right, thanks. Morning, everyone. Corlia, are you? I see you're here, but
I'm here. Thank you. Morning, Taki.
morning. I doubt I'm going to take the full 15 minutes to do the introduction and the welcome and announcements and stuff. So just wanted
Okay,
to check if we can sort
No,
of
we-
start earlier, then perfect.
Yeah, and is everybody in?
I'm not yet. I'm probably still going to give them another 2 minutes after. No, it's not really fair to the people that arrived on time, but sometimes people have problems connecting and stuff. So I'll probably just give them another 2 minutes after 9. to join.
Yeah, I don't know. I'm at the office today. Yesterday we had some connection problems, so I hope our system will be okay today. But yesterday we had problems here with load shedding.
I heard yesterday from, I think from Suraj that it wasn't going well at the office. So that's why I said probably not going to come to the office.
Yeah, and I actually anticipated because I felt, it's just better attending from the office, but it looks like that we're sitting with problems here.
Alrighty. We will start. Let's see, I think we've got a good attendance at the moment, but Kia, can you put up the agenda for us, please?
Good morning, everyone.
Morning, Kia.
Just going to put it up in a moment.
All right, thank you.
Is it visible?
Yes, it is. Thank you so much, Kia. I just wanted to quickly also talk through it, so I didn't want to not have people be seeing it. And then I will hand over. Yeah, okay. Okay, I think we can get started. For those, I'm probably just in any event going to be doing introductory information in any event, so it shouldn't be problematic for the people that don't join exactly at 9 o'clock. Thank you very much for attending this webinar. My name is Takalani Lukhaimane, and I'm in the Conduct Supervision Department within the Retirement Funds Supervision Department. And we have been arranging or plan to arrange these webinars in relation to contraventions of Section 13A. They were actually meant to be much earlier in the year, but I think, once you get started, so many ideas come to you. And one of them was actually to separate the webinars, not to be combined as one big webinar for the entire industry, but to see whether we could make it that it is specific and sector related so that we can really concentrate on the specific issues within the webinar or within that sector. So welcome. Today is the first part of a 3-part webinar for the Bargaining Council funds and the industry funds. We opted to do it in 3 parts because there is a lot of information that is related to Section 13As, and the uniqueness of Bargaining Council funds and industry funds almost lent itself to us having a lot of topics that we needed to cover. We did consult with some Bargaining Council funds to come up with the topics and to really make sure that we almost curated it to be as specific and as unique as we could and detailed. Hence, we broke it up into 3 days. We really encourage you to attend all 3 days. We have sort of themed them so that we concentrate on specific themes within that area. So the next one will be communication, and we've put in also auditors to speak to accrual and cash. So there's a diverse amount of topics that we'll be covering. On our side, just some housekeeping issues. We have muted your mics. We'll probably only allow everybody to speak at the end. Each speaker will then let you know whether they want to have their Q&A after their presentation or whether they would want you to do it during, but we will then allow you to raise your hand and then you'll be unmuted for you to ask any questions. The chat box has been disabled as well. So if you could please, if you've got a question, to put it into the Q&A box instead of the chat function, and then we will attend to your query, or we'll put it to the speaker to attend to the query if it's directed at them. But without any more delay, I'm going to hand over to Ms. Buitendag. She is the head of department within the Conduct Supervision department, and she will be doing our opening address for the day. Thank you so much.
I actually had a background. Let me quickly, I don't know why my background is now gone. Sorry about that. I had one when I prepared. Looks like, let me take. Yeah. So it's not working. Let me take this one. Looks like I had a FSCI one. But in any case, so morning everybody. I'm sorry about this now. Good morning, everybody. I would like to welcome you all and thank you for taking the time out of your busy schedule to attend the Section 13A webinar. And thank you, Taki, for this wonderful introduction. And thank you for arranging this series of webinars. And I think it's going to be such an interesting topic, and I'm excited about this. For those who don't know me, I'm Corlia Buitendag, and as Taki said, I'm the head of the Retirement Fund Conduct Supervision Department, and our department is responsible for Section 13A notifications, and we're writing to employers, and we're looking at solutions for the industry to minimize this contraventions. Now, just as an overview, you all know the FSCI was created as a dedicated market conduct regulator in South Africa's twin peak regulatory model implemented by the Financial Sector Regulation Act. And for those who don't know, our mandate is to protect financial customers by promoting their fair treatment by financial institutions. And if you look at now our retirement funds, we're here to protect members and ensure that funds are treating them fairly, and to enhance and support the efficiency and integrity of the financial markets, to provide financial education and to promote financial literacy, and to assist in maintaining financial stability. One of our strategic priorities for the next 5 years is to develop a robust regulatory framework that promotes fair customer treatment, and it's one of the reasons why we're here today. Section 13A of the Pension Fund Act make it a statutory obligation for participating employers to pay over any contributions which, in terms of the rules, are to be deducted from a member's salary or for which the employer is liable. Generally, a member enjoys the following benefits by contributing to a retirement fund. On retirement, the member will be allowed to purchase an annuity. This will enable him to sustain himself financially during his retirement. If the member suffer, and if the rules provide for it, suffer disability that prevents him from working, he receives a disability benefit to sustain him financially. Or in the event that he passes on before retirement, his dependents will receive a death benefit, and this will enable the member to provide financially for his dependents in the event of his passing. This is therefore appreciated that the failure by an employer to pay over pension fund contributions has a significant impact on a member. The latest available financial information, arrear contributions in the retirement fund industry is almost 6 billion rand. And this compromise good outcomes for members that would have to retire short of his full benefit. In the latest annual report of the Pension Fund Adjudicator, she also highlighted that there's an increase in the number of Section 13A complaints. Rear contributions is also listed as one of the FSCA's top market conduct risks, which we need to report on a quarterly basis to our risk committee on the steps taken to mitigate the risks. The supervision team that forms part of the conduct supervision department will, during quarters 2, 3, and 4, interact with the chairperson and the principal officers of the funds with the highest arrear contributions. And the reason for this is to determine the steps taken by the fund to actually recover these arrear contributions, and also to make sure that the affected members were informed of these arrear contributions. As you would have seen, the FSCA has issued a communique, I think it was the 9th of June 2022, of our intention to name, we alerted the industry of our intention to name and shame employers that are in arrears on our website. We are currently busy finalizing this list of employers, and it's anticipated that we will publish this list during the end of November on our website. The purpose of this series of meetings, as Taki explained, is to go through the legislative requirements, to discuss the new conduct, the Section 13A conduct standard, and these funds that is willing or funds that is willing to share the experience, how they actually took this process forward and that successfully have recovered arrear contributions. From my side, please enjoy today's session, and at the end of the session, please send us your feedback. We will appreciate how we can improve in future. Thank you all. Enjoy today.
Thank you so much, Corlia. And I really do hope that all the topics speak to everybody. And I know you're very, very passionate about the conduct issues surrounding the non-contribution of payments. And it helps a lot to have your support when we actually have to address all of these issues. So thank you very, very much. I'm going to hand over the programs, speaks to Ms. Kamrudeen, being the speaker for the legislative, setting the legislative scene. Unfortunately, she wasn't able to join us this morning, but Tando Mbono, Mr. Tando Mbono is going to do the presentation, and he is the manager in the Fund Governance and Trustee Conduct Department, and is, I suppose, Ms. Kamrudeen's right-hand man at the moment. So welcome, Tando, and thank you so much for being able to do the presentation. And you can take over. Thank you.
Thank you, Jackie, and good morning, everybody. I'm just as disappointed as you are that Zarina couldn't be here. But luckily she had already done the presentation by the time she learned that she had a conflicting engagement. So I'm gonna get right into it, and I hope I can do justice to it. Basically, the title of the presentation is Section 13A, as it has already been alluded to by Dagi and Corlia. But I must admit, I was rather taken aback when I realized that the actual topic is sketching the legislative landscape, which, as I interpreted it, legislative landscape is something more than just one section of the of the Pension Funds Act as it relates to bargaining council funds. But as you will see from the slides, it zooms just into Section 13A of the Pension Funds Act. It doesn't cover the whole historical, background of bargaining council funds versus the Pension Funds Act, and that long-going tussle between the Labor Relations Act and the Pension Funds Act. But just perhaps just to give it, because it's rather a short slide, perhaps I could squeeze in a minute or two, Tagi, just to sketch the background in a very terse manner, because as I said, it was at the last moment that I learned that perhaps the scope is much wider than we have anticipated, or we've been advised, or had assumed. So basically, I'm sure the history of bargaining council funds and the Pension Funds Act is well known to most of the attendees and some of my colleagues. And I'm not gonna sketch the whole background, because as you will appreciate, it goes back right up to 1937, during the Industrial Conciliation Act, I think of 1937, which made provision for bargaining council funds that were able to be established by bargaining councils. And I think years later, the Pension Funds Act came into effect, but it excluded bargaining councils. It was basically dealing with private funds, and bargaining councils were formed their own pension funds, and they were run under the auspices at the time of the Industrial Conciliation Act, as I said, and that's the forerunner of the current Labor Relations Act. As most of you might remember, I think it went to many enactments and amendments to give us the current Labor Relations Act of 1995 as it currently stands. But I'm sure you'll remember that throughout the years, in the end, what was decisive of bargaining council falling under the auspices, bargaining council funds, that is, falling under the auspices of the Pension Funds Act. I think it was the Pension Funds Amendment Act of 2007, which came into effect on the 13th of September of 2007, basically making provision for funds, bargaining council funds, to fall under the Pension Funds Act, with effect from January, I think, 2008. But then already at that time, the Labor Relations Act had itself been amended, I think, by the Labor Relations Amendment Act of 1998, which made provision for bargaining council funds to fall within the Pension Funds Act, or at least to remove the exemption that they had under Section 2(1) of the Pension Funds Act. So with effect from 1999, I think February the 1st, then that provision was removed, and they were able to fall under the Pension Funds Act. So that's basically the background, and the background to it, and the changes in legislation, in the change of mind, in terms of which bargaining councils were left on their own, basically to run their own funds. It was the advantages that appeared to be glaringly, more than otherwise would be the case under the bargaining council funds. So I think the lawmaker decided to bring the pension funds under the bargaining council and under the Labor Relations Act within the purview of the Pension Funds Act. Among other reasons, I think advantages that were obvious at the time was the provision of such things as the minimum benefits, the introduction of the surplus legislation, I think in 2001, and the Pension Funds Adjudicator's Office, which was deemed to provide more redress as opposed to bargaining councils would have done at the time. So it brings us where we are. I thought perhaps just by way of background, I should just sketch that background. But I understand that there are certain disadvantages, pros and cons, that commentators are still, picking between the tussle between Section between the Pension Funds Act and the Labour Relations Act. But as I said, the focus of my discussion, which was Zarina would have delivered this morning, is in Section 13A of the Pension Funds Act, which makes provision for the payment of benefits in terms of the rules of the fund. In other words, the statutory underpin for the payment of contributions is the Act, but it is the rules of the fund that determine the rates at which contributions must be paid for those people that are within the eligibility criteria of said funds. So I emphasize that distinction, that the rules of the fund reign supreme as to the obligations of the fund, sort of the employer, as against the member or its employee and the fund, because they delineate what the split of contributions between the employer and the member should be. So one of the cases that have come before, I think, before the courts in relation to that point is the case that I've just that is here on my slide, the matter of Fund REIT Family Trust versus the Hospitality Pension Fund Provident Fund. So what had happened in that case is, as I say, the fund had claimed contributions that were short. In other words, there was an underpayment on the part of the employer, because at the time when the employer started participating, they concluded an agreement, a participation agreement, which made provision for the rate at which the employer would participate, so they would contribute. But then what the fund did was to include the provisions of the rules in that agreement, which made provision for the escalation of contribution rates by at least 1%, for instance, annually. So the employer said its obligation towards the fund is located within the agreement, the participation agreement, not the rules of the fund, because the rules of the fund had an escalation provision, whereas the fund, the agreement did not have that escalation. So the matter went to court, and the court emphasized that the prevailing authority when it comes to contribution rates is the rules of the fund, especially to the extent that those rules have been incorporated into the agreement for the employer to participate in the fund. So it underscores the provision of Section 13A that it is payment of full contributions in terms of the rules of the fund. So basically, it is a contentious point among employers sometimes who would claim that because they have not deducted the full amount, therefore they are not liable for the discrepancy between that which they have contributed and that which they have deducted. So the court in this matter emphasize the point that the Act says full contributions, which are in terms of the rules, whether or not you decide to deduct or not to deduct, or to deduct less than you ought to have deducted, you have no defense in terms of the Act and in terms of the rules of the fund. So as you know, that payment of contributions must be made to the fund every month. It's a monthly obligation, but then the Act says they must be paid no later than 7 days of the month following the month in respect of which the contributions were owing. So it further says that contribution schedules or the payment statement must accompany such payments, which is the first prize. They must accompany the payment. But where the payment and the payment and the contribution statement are not submitted at the same time, then the employer has an obligation to submit that no later than 15 days, after the month in respect of which the contributions are owing. So basically what happens is that the courts have said that there is no split responsibility between the employer and the members. It is an entire obligation of the employer to pay contributions. It is not something that it can interchange with the employer, with the employee, and on a given month say it wasn't their obligation because the member had not had deductions made on his contributions, sorry, from his salary. So it is a duty that is imposed by Section 7C of the Act and Section 7D of the Act, that the employer owes a duty towards the member, and the fund owes a duty to make sure that those contributions that are owing to the member are actually made. So in this particular case, which I have here, for Netiquette Brand Hire, this matter went to the tribunal, the Financial Services Tribunal. It was a referral, I think it was a reconsideration application that was made by the fund, having been shortchanged in their view, or at least having not gotten the relief that they sought from the adjudicator. So what the argument was made there, by the argument that was made by the employer in front of the tribunal, was that there were 3 points that the employer had made in front of the tribunal. Firstly, it said, because it was a bargaining council fund, it said at the time that the employer started, the member started contributing or started joining the employer of the employer was not a member or was not a participating employer in the fund. That's point one. And it had not made deductions from the employee's benefits or from the employee's salary for the full period during which he was employed. So what the FST tribunal found there was that firstly, the obligation of the employer to pay contributions has nothing to do with whether or not contributions were actually deducted. Even in circumstances where there were no deductions, the employer was still liable to pay the fund was still liable to pay benefits, And secondly, the argument that was made by the employer was that at the inception of the employment of the member, it wasn't a participating employer in the fund. I think the employer had started participating in the fund about 2008, when in fact the member was employed prior to that period. So there was a period during which the member and the fund, and the employer were not participating and were not members of the fund respectively. So the FST found that is not an excuse. Even if you are not a participating employer in the fund, in circumstances where you ought to have participated from the inception of the employer, you are still liable for contributions. And I'm not very sure about the correctness of the decision. I think it's a rather unhappy decision if you read it closely. But it does make an important point, which I think I've alluded to earlier, that the obligation to deduct is a statutory obligation. You cannot reserve that obligation. You cannot not fulfill that obligation, reserving it as a defense for later a use where you will say, but I have not deducted. So I think to that extent, and that extent alone, I think the FST got it right. I'm not sure about some of the the reasoning that was made. I think it's a rather unhappy reasoning, but I think for the purposes of Section 13A, it does the job, I guess. So the Act does not impose an obligation on a fund to notify an employer of any underpayment of contributions. The obligation and duty to ensure that the employer makes correct contribution payments and submit the correct contribution schedule is that of the employer. Now, ladies and gentlemen, if I may just qualify that and qualify it having regard to the case that is in point here. What had happened here is that the municipality, Ndlambe municipality, had underpaid contributions. It was contributing less than the prescribed rate. And when the fund, the Municipal Workers Fund, Pension Fund, Retirement Fund, took them to court, they took the attitude that we were not informed that all along we are under contributing. Therefore, we cannot be held liable for the shortfall. But what I want to just emphasize so that it does not appear to be misleading that there is no obligation on the fund to notify the employer of any underpayments. I think what happened is the manner in which the employer had located the obligation that it says it was of the fund to inform it of its obligation, because it said it is in terms of Regulation 33. And when the court went to Regulation 33, it found no such obligation in terms of which the employer must be informed by the fund of any shortfall. And as a result, the court found against the employer. But if you, as I have said earlier, if you consider Section 37D 1 sub D, it says the employer, the fund or the board shall take all reasonable steps to make sure that all contributions are paid. Now reasonable steps by necessary implication would include informing the fund, the employer, where there is a discrepancy. It follows as a matter of logic that you wouldn't litigate against an employer for outstanding amounts where you have not in fact informed them upfront that this amount is outstanding. But we have noticed a practice. For instance, there's a case in point where there's a shortfall and the employer does not want to make good on that shortfall, because under the rules of the fund, it is supposed to contribute a particular percentage, and the participation agreement does not make provision, for instance, for an escalation. Then the employer sticks to its guns and he says, I'm supposed to contribute 10% for the member, and I'm supposed to contribute 7% on his behalf, for instance. When there is an increase, for instance, in risk benefits, and then there's a shortfall that is snowballing over time, then the employer, in this case, which I won't mention the fund, so that the fund decided to deduct from the members' contributions in lieu of what the employer would have been liable for, because the employer was refusing to budge. So that is what this case is saying, that the obligation that the fund had did not lie within Regulation 33. But I think had the emphasis been placed elsewhere, perhaps there would have been a different outcome. Maybe not the outcome, but the court wouldn't have come to make that finding that there is no obligation on the employer, on the fund, to inform the employer. So the principal officer, authorized person, must monitor and ensure compliance with Section 13A and have a duty to report non-compliance to interested parties as prescribed in terms of Section 13A 6 sub A. So basically, the Act make provision for the principal officer or an authorized person. And the said authorized person must be brought to the attention of the authority. In other words, the authority must be informed as to who the authorized person is. And the principal officer and the authorized person under Regulation 33 are both called the monitoring person, who have an obligation to report when the contributions have not been paid. So there are different levels of reporting, and there are different time periods. It's a lot of time periods. Colleagues, you might get lost trying to check as to who must report by when. But if we could just start from the time that contributions are received or ought to have been received, the Act says they have up to the 7th day of the month, following the month in respect of which the contributions were owing. That is when the fund is supposed to receive the money in its bank account on the 7th day. And then, as I said, if schedules are not submitted at the same time as the money, then they have 15 days within which to report. I think at the lapse of the 15 days during which the schedules ought to have been received, then the authorized person or the principal officer. And by the way, the authorized person does not have to be a member of the board or some such person. It is a person that the board would authorize to do the monitoring. So they have 15 days within which to report that the schedules have not been received. All right, and then the principal officer has a corresponding duty to report to the board, I think within a period of 7 days after it has been reported to him that the schedules and the money for that matter has not been received. So basically, what they have to check when those contributions come in is to check if there are any discrepancies, for instance, in the amounts of contributions that ought to have come, and in the number of people in respect of whom the contributions ought to have been made, and if there were prior irregularities, for instance, on the preceding month that had been spotted, whether or not those have been rectified. So that report goes to the board, coming from the principal officer or the authorized person. Then the board has an obligation further to report, but it has to inform the authorized person or the principal officer to report to the members, I think within a period of 30 days, the members in respect of whom the contributions were not made. And if those members are not identifiable to the entire body of the membership, that contributions have not been made. And I think it is only fair that principle is observed, because we have seen many a times complaints that, for instance, would come before the adjudicator where members were none the wiser. All these years that contributions are coming out, deductions are coming out of their salaries, and under the false belief or false sense of security that their futures are secured, only to learn at that stage that there were never contributions made on their behalf, notwithstanding the deductions in extreme cases, but in some cases there will be no deductions. So that is what that section is, among other things, in my view, seeks to cure, that you are not taken by surprise when the time comes that you retire and all along you learn that you have not been contributed for. So those are the reporting duties of the principal officer and the authorized person, and obviously that reporting goes onwards to the authority for instance, if the infractions continue for a period of about 90 days unchecked, so the principal officer, sorry, the board will then be obliged to forward reporting to the authority. Sorry, I'm just trying to scroll down. It's not moving. So as I said, that I think I have already made the point that the reason that the board has the duty to take reasonable steps to ensure that contributions are paid timelessly to the fund, and the courts have interpreted that section to mean, among other things, that duty involves litigation. In other words, you must pursue by way of a court action the non-payment of contributions. So it is not just lip service that we have reported to the members. For instance, they know that nobody is contributing. So you must, or let me say not must, but that obligation is interpreted to include litigation. And I must admit, I notice a trend, especially with industry funds like in the municipal sector, who are very litigious about these matters. They don't take it lying down. I have about 2 funds or 3 in mind that have really developed the law in respect of Section 13A contributions, because they really take this duty very seriously, and they don't shrug their shoulders and say there's nothing that we can do. So coming to the issue of late payment interest. Late payment interest is payable in respect of unpaid contributions. Interest at the prescribed rate becomes payable by the employer, which runs from the first day after the expiry of the period in respect of which the payment was due until date of payment to the fund. It is on a compound basis, and it constitutes a investment income for the fund. So if you look at Section 37 of the Act as cited there, and you look at Regulation 33 sub 7, you'll find something there that is a bit of a discrepancy. But you have to look very closely if you have to know what you're looking for. And I'm not going to get into that discussion, ladies and gentlemen, because I have seen literature and commentary that is divergent as to when do you start counting for the interest. And I don't want to be controversial, because this is not the position of the FSCA. I just wanted to point out that if you look closely at those two provisions, the regulations and 1387, you'll find that there's a if you start at the wrong place, you may miscalculate the interest. But at any rate, it starts from the first day following the lapse of the period during which the contributions were supposed to be paid, and then it runs until the contributions are paid. All right, on a compound basis. And I think the prescribed rate, as I understand the conduct standard, is prime plus 2%. And of course, it is on a compound basis, and it is investment income for the fund. It belongs to the fund. All right. So another enactment which I think is underused in my view, given the level of non-compliance with Section 13A, is the personal liability for late payment or non-payment of contributions by Board of Management of the employer. So it says if the employer is a company, every director regularly involved in the management of the company shall be personally liable for compliance and for payment of outstanding contributions. If the employer is a CC, every member who controls or is regularly involved in the management of the CC's affairs is liable for compliance and the payment of outstanding contributions. And any other employer, any other person on whose instructions the governing body acts or who controls in or regularly controls in the management of the employer's financial affairs. So those are companies that or entities that do not fall either under a company or under a closed corporation. So what the Act says, I think, if you read it with the conduct standard, is that the fund must be informed by the employer. And I think in terms of the conduct standard, that person is communicated to the fund upfront in terms of the initial contribution statement that the employer must know, but the Act says at the request of the employer. Of the fund, the employer must divulge as to who is the person responsible for the financial affairs of the fund. But I think the conduct standard narrows it, if I read it correctly, to say that communication as to who is the liable person must be upfront, so it must always be known to the fund that this is the person that we are going to tend to in the event that contributions are not paid. And where such a person is not identifiable, obviously the entire body of directors of that fund who are regularly involved in the management of the fund and are liable personally for the payment of contributions. Now there's an interesting case which I have not had opportunity to include in this provision, which for me is the first case that I've seen where the fund has really gone after the director of an employer where they have not paid. It's a Cape Court decision, but I think the points that are made there and the defenses that are made there elucidate the scope of this provision. So what happened in this matter is that the man in question was the sole director of the employer, and the employer had fallen behind in paying contributions, and it was taken to task by the fund. So the employer and the director were joined as first and second respondent, but I think the first respondent was the director. So what happened there is that the defense that was raised by the board member, who was the sole director of the company in question, he said, first of all, the liability of a director in circumstances where pension fund contributions are not paid is accessory. It is not a primary liability, because the liability attaches to the employer in the first instance. So his liability is accessory in the event that the employer is failing to pay the contributions. So he took that point further to say the employer must first be squeezed for contributions. Only in the event that it does not succeed in getting the money from the employer, can it then proceed to the individual director. So that was the first point that they took. And in the alternative, they said the entire scheme of section 13A8 runs counter to the Companies Act and the Close Corporations Act, in terms of which there is a corporate veil between the director and the company. In other words, company directors may not be held liable for the debts of the company. It is because they have a they have a legal persona which is separate from its directors. So they argued. So the court did not accept that argument. the court did not accept that argument. It said the entire purpose of Section 13A(8) is to pierce that corporate veil between the director and the company, and that should be done without more. There are no other procedural niceties that ought to be complied with before you can move on. The only thing that triggers the provisions of 13A(8) is that the employer is in default. So without more, the company can proceed, the fund can proceed against the company and against the director. And it was an individual director in this case, as I say, and get its money. And the court ordered as such. And the director was held personally liable. So I think that's, to the best of my knowledge, is about the only one that I've seen, which I think is quite important to move the needle forward in terms of taking company directors personally, making them personally liable for failure to pay contributions. So I think I've already covered this non-payment of contributions and the payment of excursion of committee directors in the previous slide. So basically, under Section 37A, Section 37 of the PFA, a violation of Section 13A attracts a fine of up to 10 million or a period of up to 10 years for failure to comply with the provisions of Section 13A, among other provisions that are provided for there, in terms of which you may be liable criminally and be fined for failing to pay contributions. So the case in point here is joint municipality versus Ehlanzeni district municipality, where just to dovetail with the point that I had made earlier about the obligation of the fund or the board to pursue litigation on behalf of the fund. Sorry, on behalf of the member, where the employer has not paid contributions. So what had happened in this matter, the Joint Municipal Pension Fund took the municipality to court for outstanding contributions in respect of I think it was one member, as a matter of fact. That is how seriously this fund took this case, as to go directly to court to pursue contributions in respect of just one person, as I recall the facts. So the attitude that the municipality took there was that the fund does not have a legal standing to bring an action against the employer on behalf of the member. So the member ought to have brought the application or the action on his own without the assistance of the employer. At least that is what the municipality argued. And quite strangely, the court upheld that argument. The court upheld that argument, finding very strangely that the fund is not a creditor to the employer. It is a conduit of the member. In other words, the benefits of a pension fund, it's the strangest argument you will ever hear, but the court upheld that argument, at least the court below, because the matter went to appeal. The court said the benefit, a pension benefit, is payable by the employer on behalf of the member via the channel of the fund. Therefore, the fund does not have legal standing to bring that application in its own name without joining the even if they join the member, for instance, they still said, but The master of the suit is the member, not the employer. So not the fund. So as you can imagine, the matter went on appeal, and the court decision was reversed. But there's really it's really a hollow victory, to the extent that the arguments in the first place were far-fetched, and the court could not have, properly directing itself, it couldn't have come to a decision like that. So it restored, the appeal court restored what is otherwise settled law, that the fund may bring proceedings in front of the court in pursuance of a claim that it has, although the beneficiary in the ultimate will be the member who otherwise would have been paid a benefit, but for the non-payment of contributions by the employer. So that, ladies and gentlemen, is what Zarina, I hope, would have told you. I hope I'd covered a bit of ground, and I know that some of my colleagues are actually the doyens of this section. But that's the end of the presentation, and I think that Teki had asked whether questions would be taken immediately after or right at the end. I think I would rather take them right at the end. I need to drink some water. I think it's an intimidating section because of the permutations that are inherent in it. But thanks a lot, Teki.
Thank you, Tando. I was actually about to ask you to take a question, because I saw there was a hand up, but the hand was taken down. So I was about to ask you, but perhaps I'll just ask Richard if you can post it in the Q&A, your question, and then Tando will take it at the end. At least today we don't have a very long session, so the Q&A will be right after the speakers in the second session. I think we are into the very last presentation, or the very last speaker, for just before our break, and then we will come back and have another session, or the second half of the session. But Tando, just some highlights from your presentation. I also really appreciate the fact that bargaining councils all have this other process that they'd been following in terms of recovery of arrear contributions. It was one of the things that we could actually lean on, so to speak, in the Pension Funds Act, to say, at least bargaining councils have this process where they'd always been implementing to bring the employers to book. And for some of them, it works really, really well. And it does supplement quite well with the Pension Funds Act and the provisions that are in there. And also just the interest rate, the fact that in actual fact, there was a misalignment between the provisions in the Pension Funds Act and the provisions in the regulations, in that the regulation actually said that it would be at the first day of the month, and the Act was actually saying something else. So we've aligned that in the conduct standard. And I'm hoping our next speaker is ready. I did see she had already joined. I'm hoping that I will disappear from the front of the screen as well at some point. Yeah, so that we can hand over to the next speaker. Is everything fine on your side, Kia?
Hi, Taki. Everything seems to be okay on my side.
Okay, I see, I'm just seeing me on the screen and the presentation at the back.
Oh, Tando's still sharing. Tando, can you please stop sharing?
There we go. I thought it was. Thank you so much. And I really, really have the pleasure of introducing our next speaker, which is Ms. Mary Ngwetjana, who is the Deputy Registrar in the Labour Department. I'm quite sure that the people in attendance are more familiar with your duties and your responsibilities than we are, since you register their parties and you also register their bargaining councils. For the longest time, you know, we've wanted to always establish a relationship to be able to work together to make sure that the environment within which the bargaining councils and all the parties that you regulate, you know, is collaborative, instead of us looking at it from a labor relations side and them having to look at the pension fund side. So we're really, really excited about you being able to join us today and to speak today. And thank you very much. And I'll hand over to you now. Thank you, Ms. Ngwetjana.
Good morning, ma'am, and colleagues who are attending the webinar. As Ms. Lukhaimane already introduced me, I think many of you already are familiar with myself. My name is Ngwetjana. I'm the Deputy Registrar of Labor Relations in the Department of Employment and Labor. I was invited to be part of this webinar, and I have some few points that I was requested to speak on, which I'm going to talk to in a few minutes after this introduction. The first point that I was requested to speak on is the main functions of a bargaining council. A bargaining council, their functions are outlined in the LRA, in section 28 of the LRA. And some of the functions, I'm not going to mention all of them. I'll just mention a few of them. It includes the following: to conclude collective agreements, to enforce those collective agreements, to prevent and resolve labor disputes, to perform the disputes resolution functions referred to section 51 of the LRA, to establish and administer funds used for resolving disputes, to establish and administer funds such as the pension provident fund in the industries that the bargaining councils are operating under, to name but a few of the functions that bargaining councils are responsible for in terms of their functions. The other issue that I was requested to speak on is the makeup of a bargaining council. A bargaining council is formed by registered trade union, one or more, and a registered employer organization, one or more. They are the ones who can be able to form a bargaining council. And that bargaining council, they'll follow through the due process in terms of the LRA to register a bargaining council, which is going to be processed by the Office of the Registrar through NETLEC, determining the sector that they are operating under and the area that they are operating under, and the representativity regarding the figures that the parties are having in terms of that sector that they are operating under, and then the bargaining council will be able to be registered. And there are obligations that bargaining councils they need to be compliant with from the Office of the Registrar, which include submission of audited financial statements, submission of the details of their office bearers, to name but a few. And we are closely linked with collective bargaining as the Office of the Registrar, because when bargaining council they choose to extend their collective agreements to the industries, they will request the minister through the Office of the Department, the Office of Collective Bargaining, for the Minister of Employment and Labor to extend such collective agreements to non-parties. So when we receive the request from the bargaining councils for the minister to extend those collective agreements to non-parties, non-parties are basically employers and employees in the industry who are not party to the bargaining council. So they will decide to say that they will want whatever agreement, whether it's a main agreement, provident fund agreement, pension fund agreement, that they will request the Minister of Employment and Labor to extend that agreement to the industry. And that agreement will be processed through the Office of the Collective Bargaining and through to the minister, and then it will be gazetted as the law that regulates the industry after the minister's signature in terms of that extension. The other point I would like to talk to is what is the main or the collective agreements and what are the key areas of the agreements. The agreements that bargaining councils conclude on, they vary. There's a main agreement which in many cases encompass wages and conditions of employment. The bargaining council can also choose to have a provident fund agreement which is separate from the main agreement. They can also choose to have a pension fund that is separate from the main agreement, and they can decide to have levies agreement and dispute agreement, to name but a few of the agreements that they can choose to have in the industries that they are operating under. And they will choose also that they will want the minister to extend those agreements to non-parties to enable that they should be able to level the playing field in the sectors that they are operating under. But they can also choose that they don't want the minister to extend those agreements, and then those agreements are not submitted to the department for the minister to process. They will only apply to party situations only. On the issue of the areas that the main agreement provides, the agreements, each and every agreement, before it is submitted to the minister, it must provide for an exemption process. The exemption process enables any person or employer or employee who's affected by the agreement, if they feel that they are not able to comply with that collective agreement, that agreement, they can be able to apply to the same bargaining council. They apply for exemption so that they can be exempted from those relevant provisions of that agreement. So that provision, there's no agreement that the minister can extend without that exemption procedure. And the other process that must be in an agreement is the appeals process. The appeals process is when you are not happy as an employer, employee, or any other person that is aggrieved by the agreement, that they can appeal to the bargaining council. The bargaining council will institute an independent body which they will make a decision whether they will look at the merits of the application from an employer, an employee, any interested party that is aggrieved, and then they will make an independent decision from the parties to the bargaining council. And that process is independent of the council, and the people that are also sitting on that board or in an appeals board are independent from the council. That is a requirement in terms of the LRA, so that process can be independent from the parties in terms of influence, because the parties in most cases, they have an influence in the process regarding exemption process. That's where many of the parties will be sitting on and making those kind of decisions. And the other process that the agreement must have is an enforcement process. Bargaining councils, they employ people that we call designated agents. Designated agents, in a sense that these agreements that they are asking the minister to extend, they will want those agreements to be enforced in the industries that they are operating under. And in that case, they will apply to the office of the registrar for, after they've appointed a particular person who is in their employ to be an agent to enforce the agreement, for to designate such a person as a designated agent. So the powers of a designated agent are wider, in a sense that a designated agent will be able to go to companies' premises, approach employers, enforce the agreement, even in those companies where parties are not members of, in parties that are in the industry that we call them non-parties. So the designated are enforced, are the ones who are able to go and enforce the provisions of the agreement in terms of that. And the other provision that is provided, that I think I already mentioned, like, for example, if, let's say, a particular bargaining council, they decide that they want to have a provident fund extended to non-parties in the industry. From the approach of the department is to say that we are not the custodian of the pension or the provident fund. The FSCA is the one that is the custodian. And in that sense, we request them to prove that indeed they have satisfied all the requirements that are set on them by the FSCA before they come to the minister, because the minister is not the primary regulator in terms of the pension and provident fund. So we will be requesting information such as the rules as approved by the FSCA. We will request them to indicate who are the fund administrators. We will request them to provide the details of their board of trustees. We request them to provide us with a copy of the audited financial statements that they provide to the FSCA, so that when we prepare a submission for the minister, that it can be clear that the minister is not the primary regulator. The FSCA is the primary regulator. In the cases where a bargaining council, they find themselves in hot water by not complying with the FSCA, unfortunately, the minister cannot be able to override the requirements in terms of the FSCA. They just need to prove. That is why in some of the bargaining council, you find that they decided, because of all the requirements of the FSCA and the other issues, they will decide to say, you know what, it's better that they deal with all those matters that the FSCA require of them in terms of compliance. And they might decide not to even request the minister to extend those agreements, the provident fund and the pension funds, to the industries. There will be, so if we receive complaints, for example, from employees, which sometimes we do, because we have a close working relationship with the bargaining council, when we receive such a complaint, we are not going to tell that complainant to say, it's not our problem, go somewhere else. We will take that complaint, refer it to the bargaining council. The bargaining council will refer it to the relevant provident fund administrators, so that they can be able to provide answers for the complainant, who could be a member or a dependent of that a member who have maybe deceased in that situation. So we have that close working relationship with the bargaining councils in terms of how they conduct their business, and the regulator in terms of the bargaining council is the office of the registrar, because it's the registrar of labor relations and the office of the registrar that register bargaining councils, and they are responsible to the office of the registrar. That is why we have that close working relationship. And if there are issues that maybe we need to bring to their attention, we appreciate that we are also invited, and we also partake to be able to assist them to solve or to get assistance in terms of resolving those matters that they might be facing with compliance with other regulatory bodies in terms of government procedures and all the other government departments and FSCA and all the other departments. So we closely have that working relationship with bargaining councils. I've already touched on the issue about the complaints, but I think I will go further to say that we do receive complaints, but there are not that many regarding the pension and the provident fund complaints. When complaints, the employees or the dependents, they come to the department, we will take those complaints, and I think the complainants, they usually see the Department of Employment and Labor as closer to them in terms of understanding that these are issues that are involving employees, deceased employees, and our office and the department, they are closer to try to find resolution to those matters that affect those dependents or members. So we will escalate those complaints when we receive them to the bargaining councils, and they will gladly take those complaints to the administrators of the fund, for example, to find the resolution of those complaints that have been brought to their attention. And then we will, when receiving the response from the bargaining council, from the administrators as well, we will provide the complainant with the response that we would have received from the bargaining council and through the administrators as well. So we have that even if it's not written down, but we have that close working relationship that If there's a bargaining council, there's a provident fund in the industry, the bargaining council will gladly be able to take the matter with the administrators to try and get to the answers for that complainant in order to resolve the complaint that the member or the dependent is having in terms of the complaint that has been lodged. I think I will end there. I will take questions if they're available at the end of the session according to the directive from the program director. Thank you very much.
Thank you so much for that, Ms. Ngwetjana. I think we probably learned a lot more than the bargaining councils did, which is already a lot in terms of assisting us in assisting them. I do see there's a hand from Luyanda, and it was up before, so I'm hoping maybe you will just indulge us to take Luyanda's question now instead of waiting until the end. Is that okay, Ms. Ngwetjana?
Yes, it's fine, ma'am.
All right, thank you so much. Gia, can you unmute Luyanda, please?
I have allowed Luyanda's mic. They can unmute on their side.
Okay, thank you so much.
Thank you, Program Director. Look, I apologize for joining late. I was in another meeting. However, I came in during a very important part that affects us a lot in the Bargaining Council, which is the non-compliance of Section 13A. And I just wanted to ask one thing, I just want to ask one thing. So somebody's disturbing me. The Section 13A, is there a possibility that we can be clarified more, maybe in another session that will come, because I've seen this is not the last session, I joined late. Because in our bargaining council, we've heard most of the time that it's not easy, or it takes longer to prosecute employers who contravene this Section 13A. That's my first question, because as it stands now, I've got a problem in my hands where a company has not been paying provident fund or pension fund of employees since February 2022 till to date. And we've entered in some kind of agreement separately from the bargaining council just to make sure that employees do get covered in terms of risk. But I don't see much of teeth in terms of making sure that employers under the bargaining council do not from time to time contravene this Section 13A, because it puts employees at a serious disadvantage in terms of risk, because whenever there is somebody that passes on, it means those employees are unable to claim directly from the bargaining council provident pension fund, and then the employer will have to or wants to see themselves entering into some negotiations with trade unions if there are trade unions involved, because at that time you've got a body that needs to be buried. That's the one thing. That's the one thing that I wanted to raise. I'm not sure whether it's a comment or a question, but I just want to check if there are any ways of making sure that bargaining council have got more teeth and there is a faster process in terms of dealing with these companies through NPA and SAPS. That's the first question for me. The second one is the pension provident fund extension from the last presenter. I just want to check. Let's say the minister declines to extend the collective agreement of a certain bargaining council.
Sorry, I see we might have lost Luyanda's sound. Corlia, is it just me or can you hear me?
I can hear you, Taki.
I think we've lost.
Yeah.
Luyanda, your sound has gone off.
It's maybe load shedding.
Yeah, perhaps because it's but I think the first question is I suppose directed at me, Corlia. I don't know if you wanted to take that.
No, you can take it, Taki. I actually.
All right. No, I think but Leander might not be able to hear us, so maybe we just park it and we see whether he can continue his questions after. We are almost at the time for, well, a lot earlier in terms of the time for the break. But I do think that that is actually a good thing because everybody must be already, waiting to have a leg stretch. I think we can have a, say a 20-minute or a 15-minute leg stretch and let's get some coffee and tea and then be back for our next session by, say 22 or earlier. Kia, what would 15 minutes look like? Is that okay with you? Because I know you are managing our time quite well.
Look, I think we can take the break as per the program, so we can take it at 10:40. Maybe what we can do, because I do see that Richard has put his hand up again, and there's
Yes.
another question from Franklin. So maybe let's take their questions,
All right.
and see if Tando wouldn't mind, perhaps if there are any questions. Oh, there's Luyanda. If there are any questions for him as per the Q&A, if he can respond maybe to some of those questions before we take the break.
All right, awesome. I told you she's managing our time really, really well. So thank you, Kia. I think then you can unmute Luyanda maybe to continue with his question, and then we'll answer his and then come back to the rest. Thank you.
Luyanda, we have unmuted your mic, or we have allowed your mic. Can you unmute on your side and continue with your question?
Yes, thank you very much. I'm sorry, something happened and you've lost me. Apologies for that. The last question I wanted to check was saying that Pension Provident Fund extension. I listened very carefully when the Deputy Registrar was presenting this one. I just wanted to check if a bargaining council happens not to get their collective agreement extended by the minister, depending on the reasons. It therefore means that a lot is at stake from where I'm sitting, means that employers will especially those that are non-parties, would not be forced to follow that collective bargaining council agreement. Just wanted to check the Pension Provident Fund, which is the most important benefit for employees. What is the remedy to make sure that even the non-parties do not get to scrap the Pension Provident Fund that they were complying with when the collective bargaining council was in place and was extended by the minister? I'm not sure if the Deputy Registrar gets my question clearly. Thank you very much. Hello?
Yes, no, we can hear you. Thank you, Leander. I think I will take the first question in relation to trying to get more, I want to say, teeth into prosecuting employers. That is, I want to say, basically the actual intention of us having the webinars and also having the conduct standard. I know that is the biggest issue is not being able to enforce the provisions. I know Tando also mentioned, that one of the really good provisions that have been introduced is that you can actually go after the directors in their personal capacity. And it's very difficult to do that if the police are not cooperating with the funds. From our side, it's very difficult it has been quite difficult to get commitment, and I know it was also addressed by our divisional executive, Mr. Makubela, about the fact that it's difficult to commit someone else's resources, being the prosecuting authorities, to prosecuting some of these cases. I know that there are some sporadic, I want to say in different areas, there are some prosecutions that are actually taking place, but it's not consistent and it's not being followed through by the majority of the police stations or the majority of the regions in terms of prosecution. So it is very difficult. We are, I want to say constantly, because it's me that's in charge of doing it. So we are actually constantly trying to get to make some progress in that regard. I know I'm working on a particular case now with the NPN, trying to see whether we can get some prosecutions and also other solutions that we might work on, whether it's training of police or getting a dedicated person or people to deal with the cases. So it is ongoing. We know it's a very big challenge. And we're trying to find other ways as well, not to get to the stage of prosecution where we know that it might be difficult. So we're also imploring on funds to try and find effective ways of ensuring that there's timely reporting, and also that there are other mechanisms to ensure that you can work together with the employers where they are willing, you know, to contribute and to continue, because it's also a very difficult thing to say to an employer, you will contribute when they don't have any money to do so. So I think we need to find ways in which we can be a little bit more agile in terms of accommodating employers, because we don't want them to then get out of the system and view it as something that becomes too difficult to comply with, and not want to participate in the system at all. So Leanda, it's really absolutely the main purpose of us engaging with the funds, and also on our side, if you've got any other, you know, ideas or solutions, because there will be other funds that are also presenting as well to tell you what they are doing. So perhaps that will also assist, and the platform in terms of all of us coming together will be a little bit more beneficial. But I'll hand over to the Deputy Registrar to take your second question as well on the Bargaining Council agreement.
Okay, thank you, ma'am. I will try my level best to answer the question. My understanding of the question, when it comes to bargaining council, it should be understood that they are a voluntary process between registered employers and registered trade unions. And the minister, there's nothing in the LRA which the minister can use, or the tool that the minister can use to compel a bargaining council to submit an agreement regarding pension or provident fund. There's nothing in the LRA, unless the LRA is amended to make it mandatory. The minister has to operate within the confines of the law, unfortunately. And we understand the importance of pension and provident fund, but our hands are tied in a sense that you can only deal with an application which is compliant in terms of the LRA. And if, let's say, a bargaining council, they choose that they will have a provident fund, for example, and they don't want it to be extended to non-parties. Unfortunately, there's nothing in the LRA which the minister can unleash on them to say you are forced that you must have a pension fund or provident fund that is for the industry, which will cover non-parties. So unless the act is amended, unfortunately, our office and the department, where a creature of statute, we have to comply with what the LRA is saying and comply with all the relevant laws that are applicable. Thank you very much.
Thank you, ma'am. I think we can then take Richard's question. Kia?
Richard, we have allowed your mic. You can unmute on your side.
All right. Thank you very much. Can you hear me?
Yes, we can.
Yes, we can.
All right. I just want to be clear on the issue of employers who does deliberately having signed an participating agreement and agreed on the point of contributing 7.5% as the Act says 7.5%. Then that particular employer come to a point where says that I want to increase from the agreed amount which was agreed by the union, because normally unions agree with them to say no, each and every year we gonna maybe push 1% up every year when we make this thing of the wage negotiations. So the company director come to a point where they take their own decision deliberately to stay on 5%, and we try maybe as trustees to when we meet as in boardrooms to let the administrator be aware of the situation, and you find out that this particular company is doing that deliberately. I just want to understand on the side of fiscal and the side of the bargaining council, how can you definitely help us out regarding that, because I don't think us as trustees can run to the company directors to engage them. I don't think we definitely allowed to do that. Thank you very much. I will appreciate to get a clearance on regarding that.
Thank you, Richard. I'd actually wanted to ask Tando if he would be willing to take that question in terms of answering it. Tando, would you want to answer that one?
Okay, Jackie, can I? Yes, thank you.
Yes.
And I just want to go back to the cases that I cited earlier, and the particular case that is not in the presentation, which is a case that we are sitting with, where employer is digging its heels and it says under the rules of the fund, this is the percentage at which we must contribute. Then the costs, the fund expenses and the risk benefits and all of those things escalate. But then there is no escalation provision to go with that. For instance, in the rules, it's a 7% and 10% split. Under the rules of the fund, there's nothing that you can do, because as I said, Section 13A says contributions payable in terms of the rules of the fund, which is the problem that led to the fund in this case deducting from the employee contributions, because the employer wasn't budging and the rules were on its side, because the rate was set there. So for better or for worse, the provisions of the rules will always prevail, even if they cut in favor of the employer. In this case, I don't think there's nothing that you can do. But in relation to a collective agreement, I don't know what the union inner workings are in terms of bringing them, because I would presume that those collective agreements are binding agreements. They're not nice to have. They must have some provision, enforcement provision, where the employer is not playing the game, but having been bound by the collective agreement. I would presume that collective agreement is enforceable against the employer. Obviously, I don't think in a unionized environment it would be up to the members personally to take that when it's a unionized environment where the unions can take it up. That's my take, Doug.
Thank you very much. Thank you very much, Tando. I think if I could just add on Richard's side, I think they should also be, perhaps some communication between, the fund and the employer, whether it's through the, the trade union or even through the employer associations in the bargaining council setting, but just more on demonstrating perhaps why the increase would be necessary. So as Tando said, you can't make them contribute more, but perhaps demonstrate how costs are escalating, which might necessitate an increase for their members to retire with a better retirement savings. So, and I know these things are tricky, but I'm trying to say, let's not see it perhaps as a adversarial, situation, rather than saying let's work together to see how best we can provide a better retirement savings for members. Kia, can we unmute Mr. Nkaba?
He has been unmuted.
Thank you.
Or we have allowed his mic, yes.
Okay, thank you. My name is Franklin Nwaba. I'm the Legal and Compliance Manager at the Hairdressing Bargaining Council. Look, I appreciate the legal principles that were tabled by Tando. They were quite helpful. And they also shed light on the Bargaining Council's responsibility at large. My question is pertaining to an issue of contribution, because Tando said not deducting the contribution from the employee is not an excuse. What approach would one take in trying to recover what was not contributed by the employer? Will the employer be the one liable to only contribute the company's contribution in the absence of the employee's contribution? Bearing in mind that if it is for the lengthy period, a substantial amount will have to be deducted from an employee. Do we say, employer, contribute what you ought to have contributed and continue contributing from the employer for the employee subsequent to you having paid your duration of payment? Or do we hold the employer accountable for both contribution, the employer's contribution and the employee's contribution? That's my first question. The second question is on issues where an employer has been deducting from the employee but not paying over. Obviously, such a situation has a criminality element. I had issues where an agent will say, when I approach the police station, they are not willing to take such a case. I think it will be helpful if we could have a standard approach to assist the bargaining council to say, look, under those circumstances, what do you then do? Which is an approach that will be speedily, bearing in mind that litigations are lengthy. And you might be litigating with the employer and an employee passed on. The family suffers, they cannot claim. I think if we can have an approach that will speed up taking actions where there is a criminal element. And lastly, at times when a company fails to pay over statutory payments and the matter goes through your arbitration process, the commissioner found that they failed and he issues an award that says they should pay. They don't pay, the matter goes to the sheriff. And the sheriff will go to the premises. Employers have become so innovative that they conceal their assets. Or the sheriff will find assets and they'll say, no, these are not my assets. This maybe a chair is the only asset I have. Where the amount that the employer or the company is liable for is more than 100,000. You get a chair of 100 Rand, and to take actions further, it's kind of a loss taking into consideration that the amount the sheriff will be charging. I think if we can also look into that, because at times companies have money in their bank, not for recovery of monies, we should not only focus on assets. I think we should dig deeper into other means we can look into to ensure that whatever that is owed is recovered. Thank you.
Well, thank you very much for those comments. I think Tando, if you can take the first one, but I'll wait for you to take it at the end. I think I want to take the question on the criminal element. I want to agree with you that definitely there is a criminal element, and that is why there is a statutory contravention, precisely because also it is that you can refer it to the police as a criminal matter. What we've done to try and assist in speeding up the process is in the new conduct standard. I'm going to stop saying new conduct standard. In the conduct standard, the annexes that come with the conduct standard, the form that gets filled out by the fund to take to opening a case with the police, and the forms that come to the fund or to the FSEA have been consulted with together with the prosecuting authorities, so that we have a statement that in their view will capture everything that they will need in order to open a case. In our consultations, we also had, I think it was the Metal Industries Fund, also suggest that perhaps we need to approach the prosecuting authorities from the side of saying the police need to have also a case number that is related specifically to this contravention, so that the police, someone at the police station doesn't have to sort of think about where do I need to fit this in. And I think that's something we definitely need to look into and see whether we can take that further, because that will assist a lot. One, in terms of reducing, the pushback in terms of opening a case, and also streamlining the process for prosecution so that the funds don't incur costs, because that is definitely something that the funds would be considering, because whose money do you use to go after another employer? And we have to be conscious of that as well. And I in consultations with the other bargaining councils, the issue about the assets, that also came up. We think that just because someone is going to go and sell a particular asset, that the monies that the fund is owed will actually come back. I think we had an example of a cable that was going to be sold, and it was valued at 3 million, but when it was sold for substantially less than what it was the value. And we do need to find other ways to make sure that we're not just looking at assets. And I really appreciate that comment. So I don't have an answer, but I think from your side, it was also more of a comment. And we're learning from our side as well that some of the things that we might see as a solution might not necessarily play out in that manner in practice. And we need to find innovative ways as well on our side to addressing those. Tando, would you take the first question about the deductions, please?
Yeah, by all means, Taki. Okay. First of all, like I said, that in that matter of Van Niekerk, and I presume there would be other cases, I'm not sure if they will be going the opposite direction, because I haven't had the privilege of reading the adjudicator's determination on this point, because it was an application for reconsideration. The FSC said, as I had said earlier, the duty first of all, the duty to deduct is a statutory one, but the employer does not have a defense where it has not deducted against a claim for a full benefit. That's what the FST said. So, and that's the legal answer according to that decision. But then here's a practical answer. If a member and an employee at the same time knows that his contributions have not been deducted from his salary, only the employer contributions are being deducted, having regard to his payslip on a monthly basis. I think there's also a duty on the member to see to it that that situation does not continue unchecked, because as our colleague said, that it may be cumulative and burdensome at the end if you don't do that. That's one. So I'm wondering what incentive would the employer have not to deduct from the member, but it would be paying on behalf of the member for its side of the bargain. But I think it raises another question, Taki, which I've seen commentary on, as to whether or not the payment of a benefit under the rules of the fund, a determinable benefit, is determined by whether or not contributions have been received or have not been received. And I think that the attorneys that have come before the adjudicator in the past have argued that if the rules of the fund say contributions payable as opposed to paid, then there's good grounds to have the fund pay the benefit, notwithstanding that contributions were not paid in full, because the rules contemplate payable contributions as opposed to paid contributions that were in fact paid. So there's if that argument is correct, I'm not sure of the answer, because there's contradicting views on that score. But the fund itself has an obligation, as we have said, that if the non-contribution continues to a period of 90 days, it becomes reportable, and there's an obligation on the fund to take action against failure of the employer to contribute and deduct from the member. And I know, Taki, you've dealt with a matter where there was a collusion between the employer actually and the members, that the employer would not deduct. But I think there's obligation on both sides, the employer and the member and the fund, because each and every one of those three stakeholders is settled with a particular responsibility under 13A. But I would imagine that I'm at a loss as to how the employer would have an incentive not to contribute or deduct from the member when the money is deductible from the member's salary, but it would pay from its own coffers on behalf of the member for its own share. So the short answer is in the Act that the fund must act, because it has to reconcile those contributions every month. If there's a discrepancy, the fund has an obligation to act, and the employer has a duty to deduct. And the member, being the person that is going to be informed if he doesn't look at his own pay slip, that the employer is not deducting from you. And that's the easy part, because I could understand if the employer is absconding with his own part of the bargain. But where the member is being enriched by this employer who is not deducting, I think he has an obligation to bring it to the attention of the employer. But on the authority of this decision that I said, the short answer is that not deducting is not a defense against the employer for saying I won't be liable for contributions because I've not deducted.
Thank you so much, Tando. I see we've now almost entered into break time, and there's still some questions. So I'm just going to ask, we're going to note Linda, Omar, and Buti to see whether we can address your questions after the break, or actually at the end of the Q&A as well. All the speakers are going to still be here, so you will be able to still ask all of your questions at the end. Our break will be until, we were meant to be back at 10:55. I think let's make it 11 o'clock, and then we'll just move in the extra 5 minutes or so that we went into the break time. It is going to be a little bit shorter because it gives you almost just 10 minutes. But let's get back at 11 o'clock and see whether we can move forward that way. Thank you so much, and we'll see you after the break at 11. We should be coming back now. Kia. And I think Naheem.
Hi, Taki.
How are you?
Good and yourself?
I'm all right.
I just want to run and get some water if you don't mind. I'll just be back in a minute.
Not a problem. Thank you. And everybody, I'm hoping everyone is back from the break. Naheem has just requested an extra minute to get ready, but he'll be joining us shortly. And then I will just make formal introductions on his side, and then we'll start with his presentation.
Hi, I'm back.
Thank you so much, Naheem. I'm sure, again, everybody on the call might already know, and I'm hoping everyone is back, might already know Naheem Essop. He is at the Office of the Pension Fund Adjudicator's office. Yeah, okay. So you're at the Pension Fund Adjudicator's office. And I think I always say OPFA, so I think I started with office in the other way. Naheem is a very, very, very knowledgeable legal expert and has practiced before, and in actual fact came all the way from KZN to be with us at the FSCA and is now at the PFA, and we've had the pleasure of working with him and hope to again one day work with him at the FSCA. But I'm going to hand over to him to do his presentation on prescription. Please, the presentations will be available to you and the recordings will be available. But this is a very important topic, so please, if you've got questions, please make sure that you jot it down as he goes along, and then he'll be more than willing to handle your questions when he's done with the presentation. But thank you very much, Naheem, for making time, and I'm going to hand over to you.
Thank you, Taki. I'm just going to flash my ugly face for a few seconds and not subject everyone to it for too long. Let me just share my screen. Okay, so I assume everyone can see my screen at the moment.
Yes, we are able to.
Good. All right. Good morning, everyone. And as you know, my name is Naheem Essop from the Office of the Pension Funds Adjudicator. I'm going to be talking to you today about prescription and time barring, as it is referred to in our space in the Pension Funds Act. There's quite a lot of it's a very wide topic, so there's quite a lot of content to go through. I've tried my best to summarize it and deal with the main aspects of it. And I will go through my slides, and then I'm happy to take questions at the end of my slides. not during the slides because it's sort of like a jigsaw puzzle that must be put together. And then once we see the full picture, I think it's a better time to ask questions. Or I will also be available at the end for the Q&A session as well. Okay, so without further ado, let me start. As an introduction, so prescription is the process by which legal rights are acquired or they are lost as a result of a failure to exercise such rights within a specified period. And in South Africa, the periods are prescribed in the Prescription Act of 1969. There may also be provisions in other acts specifically dealing with time periods when legal rights are lost. Acts like the Institution of Legal Proceedings Against Certain Organs of State Act, etc. But today we're just going to focus on the Prescription Act, and we're going to talk about time barring in terms of the Pension Funds Act. There is, just to note, prescription is not something that is unique to South Africa. It's present in almost every legal system around the world. In America, they have something called the Statute of Limitations. In the UK, they have the Limitation Act. You'll find all in various jurisdictions have an act that that prescribes the periods within which you may acquire or lose a right. So there are two types of prescription. There is what is called acquisitive prescription, and as the name suggests, that is where you acquire rights as a result of a lapse of time. And then there is extinctive prescription. So I'm just going to touch on acquisitive prescription in this presentation, but the one that is more relevant for us, especially in the retirement fund space, is extinctive prescription. So we'll go a bit more in detail on that. So what is the purpose of prescription? You'll see the Supreme Court of Appeal has said that one of the main purposes of the Prescription Act is to protect a debtor from all claims against which it cannot effectively defend itself because of loss of records or witnesses caused by the lapse of time. If creditors are allowed by their deliberate or negligent acts to delay the pursuit of their claims without incurring the consequences of prescription, that purpose will be subverted. And then the Constitutional Court also, which is the highest court in our land, has also spoken about the purpose of prescription. And it has said in the RAF matter that this court, meaning the Constitutional Court, has repeatedly emphasized the vital role time limits play in bringing certainty and stability to social and legal affairs and maintaining the quality of adjudication. Without prescription periods, legal disputes would have the potential to be drawn out for indefinite periods of time, bringing about prolonged uncertainty to the parties to the dispute. The quality of adjudication by courts is likely to suffer as time passes because evidence may have become lost, witnesses may no longer be available to testify, or their recollection of events may have faded. The quality of adjudication is central to the rule of law. For the law to be respected, decisions of courts must be given as soon as possible after the events giving rise to disputes and must follow from sound reasoning based on the best available evidence. So I think the Constitutional Court has also come out quite strongly in support of time limits and prescription. And let's look at what the Act talks about in respect of acquisitive prescription. So in Section 1 of the Act, it says, a person shall by prescription become the owner of a thing which he has possessed openly as if he were the owner thereof for an uninterrupted period of 30 years, or for a period which, together with any periods for which such thing was so possessed by his predecessors in title, constitutes an uninterrupted period of 30 years. So this applies even to land. If you possess the land openly as if you are the owner of it for 30 years uninterrupted, then you become the owner of that thing. And then Section 6 of the Prescription Act, a person shall acquire a servitude by prescription if he has openly and as though he were entitled to do so, exercise the rights and powers which a person who has a right to servitude is entitled to exercise for an uninterrupted period of 30 years. So those are the two sections really dealing with acquisitive prescription in the Prescription Act. Like I said, I'm not going to go into too much of detail on it. I think it's something, sorry, I just seem to have lost my slide there. I think it's something that could be looked at for things like unclaimed benefits, etc. But those discussions are still to be had. But in my opinion, we need to start considering those sort of things. But let's move on to extinctive prescription. Extinctive prescription is the one that really concerns us now at the moment. And in Section 10 of the Prescription Act, it says, subject to the provisions of this chapter and end of Chapter 4, a debt shall be extinguished by prescription after the lapse of the period in which in terms of the relevant law applies in respect of the prescription of such debt. By the prescription of a principal debt, a subsidiary debt which arose from such principal debt shall also be extinguished by prescription. So, for example, if you have a capital amount that is owing and there's interest on that amount, if the capital amount has prescribed, then the interest will also prescribe. And then it says in subsection 3, notwithstanding the provisions of subsection 1 and 2, payment by the debtor of a debt after it has been extinguished by prescription in terms of either of the said subsections shall be regarded as payment of a debt. Okay. So what are the periods of prescription? Section 11 sets out the periods of prescription. And you will see there, for example, a mortgage bond debt and a judgment debt prescribes after 30 years. In respect of the pension funds adjudicator, you'll see there's a cross-reference in the Act to the 3-year period in respect of any other debt. So that would be under Section 11D of the Act. So there are different periods of prescriptions depending on the type of debt that is owed. And I think one point to be made here is that there is not a period of prescription prescribed for a criminal act. So if contributions haven't been paid and it's a criminal act in terms of Section 37 of the Pension Funds Act, that criminal act cannot prescribe, but obviously a civil claim in respect of that debt would prescribe in terms of this act. Okay. So so we know that prescription will or debt will prescribe after 3 years. But when do we start calculating the 3-year period? Section 12 says that it begins to run as soon as the debt is due. And but if the debtor, so in our case, if the employer willfully prevents the member from coming to know of the existence of the debt, prescription shall not commence to run until the member becomes aware of the existence of the debt. So the member has to be aware that contributions have not been paid. And then when they do become aware, there's still a further period of 3 years within which they can lodge a claim against the employer. And then it says, a debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises. And then it says, provided that a creditor shall be deemed to have such knowledge if he could have acquired it by exercising reasonable care. So if, for example, you sent a notification to the member informing them that their employer has not paid, the member receives it, but then decides not to read it, then the fact that they don't have knowledge of it will not assist them, because they could have acquired it by exercising reasonable care. Obviously, you must be able to show that the member did receive the notification in the first place. Okay, and then this is relating to sexual offenses, etc. I'm not going to go through this slide. Let me move on to section 13. And here we talk about the completion of prescription being delayed in certain circumstances. And you'll see here I've called it impediments. These are impediments to the running of prescription. So if a person is a minor or is a person with a mental or intellectual disability, disorder, or incapacity, or is affected by any other factor that the court deems appropriate with regard to any offense referred to in section 12.4. Remember, that was the sexual offenses subsection. Or is a person under curatorship or is prevented by a superior force, including any law or any order of court, from interrupting the running of prescription as contemplated in section 15.1. So this first subsection is an impediment. So things like mental incapacity, being placed under curatorship, I think being under sequestration would also fall under that. If the creditor and debtor are married to each other, the creditor and debtor are partners, and the debt is a debt which arose out of the partnership relationship. The creditor is a juristic person, and the debtor is a member of the governing body of such juristic person. The debt is the object of a dispute subjected to arbitration, or the debt is the object of a claim filed against the estate of a debtor who is deceased, or against the insolvent estate of the debtor, or against a company in liquidation, or against an applicant under the Agricultural Credit Act. The creditor or debtor is deceased and an executor of the estate in question has not yet been appointed. And it says the relevant period of prescription would, but for the provisions of this subsection, be completed before or on or within 1 year after the day on which the relevant impediment referred to in A to H has ceased to exist. So it gives the creditor a further 1 year after the day on which the impediment has been removed to lodge the claim. So the period, it says the period of prescription shall not be completed before a year has lapsed after the day referred to in paragraph 1, or I, sorry. All right, so on this slide, I've got basically an example of how this impediments works. So if prescription commenced running against a creditor, and then that creditor is placed under curatorship after 2.5 years run. So remember, it would have been completed by the 3rd year, but the person is discharged from curatorship after 3.5 years have run. The creditor will have 1 more year calculated from the date of his discharge, within which he can sue to recover the debt. Okay, and if the creditor is discharged from curatorship on the day when the 3 years have run, the same applies. So the creditor will have 1 more year after the 3 years. If he is discharged when 2 3/4 years have run, the result is the same. In all 3 instances, the creditor will have another year calculated from the date of discharge within which he or she can sue. However, if the curator is placed under curatorship after 6 months of the period of prescription have run and discharged from curatorship 6 months later, when 2 years of the original period of prescription of 3 years remain available to sue, no additional time to sue is given to the creditor, and the period the debtor spent under curatorship will have had no effect whatsoever upon the running of prescription against him. So on this slide, I've sort of tried to do my own artwork to explain how these impediments work. So you will see here at the beginning, if the prescription began to run here, and then 6 months later, the person is placed under curatorship, and then after 1.5 years, that curatorship is discharged, then the creditor still has 1.5 years left to sue. There's no impact on the period of prescription because this impediment arose and was completed within the 3-year period. So if the impediment starts after 2.5 years and then it is discharged a year later after 3.5 years, then the creditor has 1 more year to sue. And then the last example is if the impediment ran from the beginning of the period of prescription up until 2.5 years, then the creditor has 1 more year because it would affect, in that instance, it would affect the 3-year period. It would extend it by a further 6 months. So I hope that makes sense. And then it says a debt which arises from a contract and which would, but for the provisions of the subsection, become prescribed before a reciprocal debt which arises from the same contract becomes prescribed, shall not become prescribed before the reciprocal debt becomes prescribed. I think that's fairly straightforward. And then interruption of prescription. I think this is sometimes an area that is not understood, or there's a misconception of how this operates. So let's go through what the section says. It says the running of prescription shall be interrupted by an express or tacit acknowledgement of liability by the debtor. Okay, so that's fairly straightforward. It says if the running of prescription is interrupted as contemplated in subsection 1, prescription shall commence to run afresh from the day on which the interruption takes place. So it starts, the 3-year period will start running again. Or if at the time of the interruption or at any time thereafter, the parties postpone the due date of the debt from the date upon which the debt again becomes due. So that is fairly straightforward, I think, to understand. I think the part that becomes confused a little bit is where the 3-year period has run its course, and maybe 5 years later, you then get the debtor to sign an acknowledgement of debt, and then there is a misconception that that acknowledgement of debt would then revive the debt and prescription would start running afresh. So this was being cleared up by the tribunal, and the tribunal has said an acknowledgement of debt post completion of prescription does not revive the debt. Okay, then we talk about judicial interruption of prescription. Prescription is interrupted by service on the debtor of any process whereby the creditor claims payment of the debt, such as summons. You'll also note that the time barring period will also be interrupted by the lodging of a complaint with the adjudicator. Prescription is not interrupted by service of a process on a wrong debtor or if issued by a wrong creditor. Although the running of prescription is not deemed to have been interrupted if the creditor does not prosecute the claim successfully under the process in question to final judgment, no time limit is stated within which the claim must be prosecuted successfully. And then section 16 says, if an act of parliament which came into effect after the Prescription Act prescribes a different period or conditions to be met before the institution of an action, then the provision of such other act will prevail. Okay, so it's subsidiary to other acts that came into effect after the Prescription Act. And then section 17 says, and those of you who are legally trained will understand this, that your defense of prescription must be raised in the pleadings by the party relying on it. So it says a court shall not of its own motion take notice of prescription. A party to litigation who invokes prescription shall do so in the relevant document filed or record in the proceedings, provided that a court may allow prescription to be raised at any stage of the proceedings. So this is different from time barring in the Pension Funds Act, because in the Pension Funds Act, there's a positive duty placed on the adjudicator to ensure that a matter is not older than 3 years, and that 3-year period is calculated in terms of the Prescription Act. So I was just talking about that. Section 30I of the Pension Funds Act talks about time barring. So there's a difference between time barring and prescription, and one of the main differences is this act says the adjudicator shall not investigate a complaint if the act or omission to which it relates occurred more than 3 years before the date on which the complaint is received by him or her in writing. So sometimes when you lodge a complaint with the adjudicator, you may then get a response from the adjudicator saying that this incident that you are complaining about took place more than 3 years ago. Please advise us why we should not consider it as time barred. And then you're given that opportunity to put forward any facts that you would like to put forward to take into consideration. Obviously, there's all those other things that can come into play, the impediments, the suspension, interruption of prescription, etc. So those things, if you want to bring it to the attention of the adjudicator, you will be given that opportunity. And it says the provisions of the Prescription Act relating to a debt. So remember, we said debt is a 3-year period, apply in respect of the calculation of the 3-year period. So all those other things about when the creditor got knowledge of the debt, did the debtor frustrate the creditor obtaining knowledge of the debt, all those things will come into play when calculating the 3-year period in respect of the time barring. So what are the potential sources of knowledge of the debt in our space, in the retirement fund space? So any communication that's sent by the fund, you'll know Regulation 33 says, I think Tando might have covered it, says that the fund has to notify the affected members if their contributions are not paid or if their contribution schedules are not submitted to the fund, then the fund has to notify the affected members. But this becomes a challenge because funds normally rely on the employers to communicate with the members, and an employer that is defaulting on their contributions is not likely to then go and distribute communication saying to the employees that we haven't paid your contributions. Annual benefit statements. Some benefit statements might have a provision relating to are there any arrear contributions. So the member might become aware of it there. Salary advices. So if the member didn't notice on their salary advice that their pension contributions are not being deducted, then that may be a source of knowledge of debt. Obviously, sometimes, like it was discussed earlier, employers do deduct reflected on the salary advice, but then they don't pay it over to the pension fund. In that case, I think the member is excused from having knowledge of the debt. A contribution statement, report by monitoring person. So this is, I think, in respect of the fund. If the fund wants to pursue the employer for arrear contributions, then they can look at the contribution statement, report by the monitoring person. I think that was discussed earlier. And then, yes, notification to affected members in terms of Regulation 33(4)A. Okay, so we're just going to look at some case law that's going to discuss some of the concepts that I've just spoken about in the Prescription Act. And the first case is the Links case. You'll see it's a constitutional court case that was 2016, but I'm not sure when the judgment was. But it is emanating from the Constitutional Court. And this case dealt with Section 12 of the Prescription Act and the issue of when the applicant in that matter became aware of the facts from which the debt arose. So in this case, the applicant was found to have only become aware of the facts relating to negligence and causation in a delictual claim. So I apologize for the non-lawyers in the workshop, and these are legal terms. The court found that the applicant was only found to have become aware of the facts relating to negligence and causation in a delictual claim for the amputation of his thumb and loss of the use of his left arm after he had received a report from a medical doctor advising him of such years after the incident took place. And why did the court find that? It said at paragraph 42 of the judgment, it said, to require knowledge of causative negligence for the test in section 12.3 to be satisfied. So remember, we spoke about 12.3 of the Prescription Act, would set the bar too high. However, in cases of this type involving professional negligence, the party relying on prescription must at least show that the plaintiff was in possession of sufficient facts to cause them on reasonable grounds to think that the injuries were due to the fault of the medical staff. Unless there are reasonable grounds for suspecting fault so as to cause the plaintiff to seek further advice, the claimant cannot be said to have knowledge of the facts from which the debt arises. So we can see where there's the specialized type of knowledge. The person claiming would have to have some sort of report from another specialist informing them of the facts from which the debt arises. And then the court went on to say, without advice at the time from a professional or expert in the medical profession, the court could not have known what had caused, the applicant could not have known what had caused his condition. It seems to me that it would be unrealistic for the law to expect a litigant who has no knowledge of medicine to have knowledge of what caused his condition without having first had an opportunity of consulting a relevant medical professional or specialist for advice. That in turn requires the litigant is in possession of sufficient facts to cause a reasonable person to suspect that something has gone wrong and to seek advice. So interesting principle coming out of the Constitutional Court there. I wonder how it would apply in the retirement fund space, especially where we have members who may not be as financially literate as some of us, and whether they understand how pension funds work, etc., whether that could be a defense to, or that could be an answer to prescription. In the Rustov case, I think this is a case that is often cited in the pension fund space. It was decided by the Supreme Court of Appeal. And in this case, let's just look at the facts and remind ourselves about the facts of that case. In this case, the applicants were medically boarded and qualified for retirement benefits. They received the pensions as calculated until 2003, when they were advised by a consultant that they were entitled to full benefits as if they had remained in the employment of the employer to the age of 63 years. They then approached the fund's actuary, who advised them that they were wrong in their interpretation of the fund's rules. However, their doubts about the correctness of the computation of their benefits were again aroused in 2005, when they received a communication from the fund about proposed changes. On the 8th of February 2006, they filed a complaint with the pension fund's adjudicator. The complaint that the complainant's retirement benefits had been incorrectly calculated in contravention of the rules of the fund was upheld by the adjudicator, who ordered the fund to compute the benefits correctly in terms of the rules and to pay the revised pension and arrears together with interest to the appellants. So they were then dissatisfied. The fund was then dissatisfied with the adjudicator's determination and approached the High Court in terms of Section 30P of the Pension Funds Act for an order reviewing and setting aside the determination and confirming the fund's computation of the appellant's pensions. The appellants applied in reconvention for declaratory relief regarding inter alia the number of years of service to which they were entitled in terms of the fund's rules, and their entitlement to have their benefits calculated up to their normal age of 63. The High Court found in favor of the fund and upheld the appeal against the determination of the adjudicator on the ground that the complaint was time barred in terms of Section 30I of the Act, and it prescribed in terms of Section 12 of the Prescription Act. And then the matter was taken on appeal to the SCA. The SCA held that Section 30I was in substance the equivalent of Section 12.3 of the Prescription Act. At the time of the termination of their employment in 1995, the court found that neither appellant possessed actual knowledge or understanding of the correctness or defectiveness of the calculation of his pension entitlement. So you can imagine these are laymen who don't know how to read pension fund rules. They're not actuaries, so they couldn't really understand that their pensions were incorrectly calculated at the time when they were terminated from employment in 1995. The conversation with the consultant in 2003 gave rise to the first doubts in that regard, and the court said that the fact that the details of their benefits were provided to the appellants in 1995 did not mean that the deeming provision kicked in. So remember that deeming provision that talks about if you can acquire knowledge by the exercise of reasonable care, then you are deemed to have knowledge of the debt. So the court said that deeming provision did not kick in by the mere fact that they were provided with details of how they or breakdown of their benefit calculation, as the computation of the benefits was a complicated matter which the appellants would have been unlikely to understand. And then the court said the appellants possessed no knowledge or expertise in relation to funds rules. They relied entirely, as they were entitled to, upon the good faith care and expertise of the officials of the fund. The date from which prescription would have started to run was therefore in 2003. The fund commenced such payments in 1995 and had done so ever since. The only reason why they were making those payments was because of the rules of the fund to which the appellants had been contributing members. And then the court said that each time they made a payment of the pension, and that payment constituted a tacit acknowledgement of the fund's obligation to pay according to its rules. So even though they calculated incorrectly, they were still holding themselves out liable to pay in terms of the rules. And then the court says, for the purpose of the Prescription Act, that obligation was the debt that was owed to and claimable by the appellants. And then it quoted this Petzer versus Radford case, where it says, to interrupt prescription, an acknowledgement by the debtor must amount to an admission that the debt is in existence and that he is liable therefore. The fund has satisfied both requirements each month as it has paid the appellant's pensions pursuant to the rules. The consequence has been a continuing and ongoing interruption of prescription in relation to every amount each appellant was entitled to claim as his correctly calculated benefit. The fact that the fund has each month paid a lesser amount and contended consistently that the amount and no more represented the correct computation of its obligation under the rules does not change matters. And the court said the legislature intended that a partial acknowledgement of the debt should have the effect of interrupting prescription in respect of the whole of the debt. So that was the Rustov case, and then this issue of what is a continuing wrong. It often comes up in our retirement fund we need to look at what exactly is a continuing wrong. So in this case, Singh and others versus the CIPC, it said, it quoted other judgments in which it said those judgments accept that the description of a continuing wrong as one which is still in the course of being committed and is not to be located wholly in a single past action. And then the Constitutional Court has also commented on this issue of a continuing wrong. And it has said in the Vodacom case, that's the please call me case, for those of you who've been following it. It says, in the case of a continuing wrong, there can be no question of prescription, even though the wrong arises from a single act long in the past. The reason, which may appear somewhat artificial, but which is well established, is said to be that while the original wrongful act may have occurred at a past time, the wrong itself continues for so long as it is not abated. But the running of prescription in respect of any financial claim arising from the same wrong will not be postponed. Accordingly, if financial loss was occasioned by the original wrongful act, the debt in relation to that loss would become due, and prescription would commence to run when the original wrongful act occurred and loss was suffered. The result is that the impact of prescription on claims having their source in the same right may differ depending on the nature of the claim. And then those two judgments from the SCA and the Constitutional Court was then relied upon by the tribunal in the matter of R.S. Gurney and others versus Z. Mkhize. So please don't confuse this matter with, there's another matter with the same applicant R.S. Gurney and N. Mkhize. Look out for this one, which is PFA 43 of 2021. And they said, when dealing with a matter pertaining to the non-payment of a monthly pension contributions, held that each non-payment was a wrong on its own, and the fact that the same or similar wrongs were successively committed does not mean that the wrong was continuing in the above sense. So what they are saying is pension contributions do prescribe. So if you are sitting on a board of a fund, you should bear that in mind, and that you have 3 years to go and recover that money. Contributions and late payment in interest also prescribe. So this is an unreported judgment. It was sent to me by Zarina, where the court was dealing with late payment interest and whether late payment interest prescribed. And it said that it is indeed so. So there's this argument about the obligation to pay interest is a statutory obligation, so that and therefore prescription does not apply. And I think some people also use that argument when it comes to payment of contributions. I don't know where that argument comes from, but the court in this case dealt with that argument. It said it is indeed so that there's a statutory obligation to pay interest on outstanding amounts. It was also acknowledged by respondents in the acknowledgement of debt. However, the fact that there is a statutory obligation to do so does not mean that it can never prescribe. As set out above, the payment of such interest is a debt, and this will prescribe after a period of 3 years. So that is something for us to note. And I think that is the end of my presentation. And I am, like I said, I'm happy to take questions.
Thank you so much, Naheem. Oh, okay. You know, it's like a buzzer. I saw hands going up really, really quickly. I'm going to ask Tando, your hand is, your mic doesn't need to be unmuted, so we should be fine. And then we can just take the other questions as they come. Thank you.
Okay, thanks.
Actually, Tando, can you help me out? Omar has had his hand up even before the break.
By all means,
So,
why not?
yeah, so I think let me just let Omar go first, and then we can take it from there. Omar, Kias is going to unmute your mic, and then you can unmute from your side as well.
Good morning. Thank you very much. Can you hear me?
Yes, we can.
Yes,
Thank
we
you.
can.
To everybody. The first thing I wanted to say is that if I call a lawyer to help me, I'm not a lawyer. I'm not going to tell him these people are owing me debt. I don't understand that. These people are stealing money. It's just a crime. And it's a crime against the poorest of the poor. I'm not talking here about people who's got billions of rand and investing in this industry. If the Department of Labor is still here, members are forced to put money into savings. Every member, if the member have food for his kids to go to school, shoes to go to school, he has to put his money in here. And then we look after these people's money. And when the employer steals this money, then we want to color it with debt and all this. I don't understand it. You know, I'm so frustrated because it's almost like when a black guy steals money, it's a theft. When a white guy steals, it's debt. I don't understand this nonsense. Sorry, I'm sorry for my word. Sorry. The thing is this, we one of the funds that lobbied Treasury to make sure that the act is changed to this thing is changed to theft, because when they changed the labor relation law, they made everything like it's not a criminal effect to violate the labor relation law during the new government. So Treasury has done that. Since the time the Treasury has done that up to today, we have employed lawyers to do this work for us if we can. You can't collect the money at the bargaining council. You can't collect the money to go through CCMA. It's not going to work. We've done that. The employer just don't pay. So we got lawyers to go to them, and we're going right after the lawyer, the companies. We're going after the individuals. We're going after the directors, and we're very successful. We were standing now since this law was passed. We're standing at about 1 billion rand of AUDs, and we collected of that 1 billion. We've collected up to date 700 million. You're not going to get the money if we're going to wishy-washy. This is dead. We need a lawyer to tell us who's on our side, to tell us this is what the law says. Go after them, get them. But that's what I need, and that's what we have. So I'm sorry if I'm not asking a question. Maybe the question is, why are you saying dead when the money is being stolen? This is deferred wages. I worked in a factory since I was born almost. When I was 17, 18, I started working as a laborer. I was an artisan in a factory. I worked for 37 years as an artisan in a factory. That money that they deduct every day from me every month is my wages. And if I still want, I defended workers every day of my life. If that worker steals one toilet roll, he's fired. And then the employer can steal my salary. Sorry. So my question is why don't we just say it's a theft and just deal with that and make it everything clear to everybody how we're going to deal with this issue? Thank you. Sorry if I'm out of order.
No, Omar, I think you've probably summarized a lot of the frustrations that people have. You see, Lungile is like giving you a thumbs up. So I think he's, everyone is sort of agreeing with you in that sense. But I'm going to let Naheem answer your comment question in as best as possible. Naheem?
Okay, thanks, Taki. Omar, the reference to debt is a reference to the time period that applies. I'm just going to quickly share my screen again, just to remind, this is what is said in the Pension Funds Act, Section 30I, okay? It says the provisions of the Prescription Act relating to a debt apply in respect of the calculation of the 3-year period. So it's not saying non-payment of a contribution is a debt, or it's not a debt, or whatever the case is. It is saying that when you have a complaint, you have 3 years to lodge that complaint with the adjudicator, and the manner in which the adjudicator must calculate that 3-year period is the same manner in which the 3-year period is calculated in respect of a debt that is referred to in the Prescription Act. Does that answer the question? And then let me just add to that and say, non-payment of contributions is a criminal act, and that is in Section 37 of the Pension Funds Act. So there's no question about it not being a criminal act. Does that answer the question, Umar?
Oh, you're asking me?
Yes. Have I answered your question?
No, all I want to, you see, we've been very successful in dealing with this issue. And there's a lot of funds and trustees and principal officers are struggling with this. And I think we should give them solutions to address the problem and find a mechanism to collect those monies. And for me, I hear what you say and I agree with you. But for me is that area where you're going after the individual himself, and going after his house, his car, his swimming pool. That's the one that makes gives us the best returns. The guy is going to pay immediately. He might default again. We'll pay back on him. We'll be back on him, but he's going to pay because he knows he's going to go to jail, and we're going to take his stuff.
Mm.
Yes, yes, Umar. As Taki said in the beginning, she said,
you must remember.
I used to be someone that was in practice, and I can tell you, when I was acting for a pension fund, 13A contributions, we went after the personal assets of it was a municipal fund, so we went after the personal assets of the councillors, and it was very effective. So I agree with you. Thanks.
But if you don't do that, Takalani, that the problem is that these employers get clever lawyers and they'll say, don't pay, nothing. So you get good lawyers, no, I want to say good lawyers, you just get lawyers that will that defend their clients.
No, I understand, Omar, and I think that, from us engaging with most of the other funds and yourselves as well, it's good on our side to also hear what other solutions are available to us, which is important, right? So I really welcome all of the information and suggestions coming through as well, and we're all on board. We're all going in the same direction. We all want to see effective prosecution of these cases. Tando, I think you had your hand up next as well.
I did indeed. I did. Thank you. I wanted to ask Naheem, to the extent that I can still remember my question, but I wanted to build on what Richard had asked about contributions that are not paid in full, whether the employer is not deducting from the member or is not paying his share or its share. And I'm referring specifically to that case of Rousseff, I think, where he said every payment of the annuity, short though it is a tacit acknowledgement of the liability. Now, what that reasoning apply in respect of contributions, where the employer is not paying in full under the rules and is paying short? If the answer is yes, would the acknowledgement be in respect of the entire determinable benefit to the extent that you can work it out, such as was found in Rostov about the disability benefit? Thank you.
Yes, Tando, to just give you a short answer to your question, I would say yes, that reasoning would apply, but obviously each case must be decided on its own facts. But in general, I would say yes, that type of reasoning would apply. There is actually a case that dealt specifically with what you are asking about, but I can't recall it now. If I do, I will share it with you.
Thanks, Naheem. Thanks a lot.
Thank you, Naheem. Linda is next. Linda Trotter is next.
So thank you very much for the opportunity. From an administrator and underwriter perspective, there are various bargaining councils that are registered in South Africa, and we have to submit an Annexure B with all new funds that we launch for it to be registered by you guys, by the FSCA. So some of these funds, I've been in the industry for quite a long time, so I've learned that some of these funds, bargaining councils, don't have a retirement fund, or they do have a retirement fund, but it's not a compulsory fund. An employer must just have a fund in place, or the other alternative is for them to have a retirement fund in place, and it's for it to be compulsory for all companies that operate in that industry to belong to that fund. I also found that that some of these bargaining councils only apply in certain provinces, so they don't apply in all the 11 provinces of South Africa. And I've asked in the past for a list of these bargaining councils that are registered and with these 3 different options that apply to them. And I haven't been able to get anything from the FSCA. The problem that we also sit with is we get from the employer confirmation that they do not belong to a bargaining council. I always, when I ask them this question, I also add the question of, are your staff salaries scheduled or rule, what do you call it, governed by a list per job class and a schedule as per the sectoral agreement? I'm not sure whether I've put the wording correct there, but normally that's the question I ask employers. In some instances, employers don't know, or they say they don't know whether they have to belong to a bargaining council. They say they don't have, that their staff don't belong to a union. So I tell them that it's not union based necessarily. If they are in that industry, there's a bargaining council for that industry, they must make sure. So the real question I need to have answered is there clarity from your side? Which of these bargaining council funds have a fund in place that is definitely compulsory, and that if you start a business in that industry, you immediately have to register your staff on that bargaining council fund and make them become members? Obviously, those staffs that are scheduled. And which of these bargaining councils have a fund in place but don't make it compulsory? It's just there, but an employer can have a fund outside or a private fund. They just have to have a fund in place for their staff. I know that the transport sector provident fund is one of those. Then which of these are only applicable to certain provinces, and which provinces, and are they compulsory or not? That's the guidance that I need from you guys. Thank you.
Thank you for the question. I think we probably wouldn't have been able to assist you if it was like a month ago, but we should be able to assist you now. We have been given an opportunity to also liaise with the National Bargaining Council Forum, so they should have that information, and we don't have it at hand because it's not, we don't have the collective agreements when we register the rules, so we wouldn't be able to tell you whether a bargaining council is compulsory or it's not. It's in the collective agreement. I don't know whether the Labour Department would be able to tell you. I'm assuming they might, but it's also not information, like I said, it's not information that is actually with the FSCA, we would be asking for you from the National Bargaining Council Forum, but we actually don't have that information based on how we register rules and how we actually operate.
So what if an employer is totally ignorant and they say no, they don't belong? And after the fact, we've sent the submission, we've attached the Annexure B based on their instructions, and it comes out that they are actually bound by a bargaining council. What happens then?
I know in cases where, especially for the private security sector, Provident Fund as well, I think that's the only example I have. And Naheem, maybe in cases that the OPFA has dealt with, you might also be able to supplement the answer. If they were meant to be registered and meant to contribute, then when it does come to the attention of the authorities, the contributions will then be backdated to when they were meant to be registered. That's how it operates. I don't know, Naheem, if that is accurate.
Yes, Taki, that just goes to the jurisdiction of the adjudicator, and whether we have the power to enforce provisions in a collective agreement or not. And our view is that we do not have those provisions. We do not have that jurisdiction because it does not fall under the definition of a complaint as defined in the Section 1 of the Pension Funds Act. So, complaint must relate to the administration of a fund, the investment and the investment of its funds, or the interpretation and application of the fund's rules. So it doesn't say that we can deal with provisions of a collective agreement. So normally, if that comes to us, we will then write an out of jurisdiction letter, and we'll refer the person to the relevant bargaining council.
The issue I have is that if these employers have launched a fund for their staff, it will be with a, let's say in this case, with a private administrator. And they have been contributing to this fund for a few years, and this now comes to light that they should have belonged to a bargaining council. Surely they should not be forced to join the bargaining council fund, or be backdated and fined for contributions that they should have paid to that fund from whatever the period was that they started contributing. And the thing is, employers are really being harassed by bargaining council people. Are really, and in most cases, the bargaining council funds are not very well governed. That's the main issue that employers have. It's not well governed. Access to information is very scarce. In most cases, the employers just pay these monies, but they really don't have any way to confirm whether the monies were allocated correctly to each members. For example, MIPCO, their bargaining council, their auto workers and motor industries funds, they cannot pick up members by an ID number. They actually, the administration platform there is not conducive for very good service. That's one that I work with frequently, by the way. So my whole, the theft, the misappropriation of funds and the excess fees and all those kind of things that are being billed on these bargaining council funds is making employers and members quite weary. And in a lot of cases, employers are prepared to pay more than the minimum required contributions of these bargaining councils just to get their fund onto a platform where they know the money is going to be utilized and allocated correctly, where members can get member level access to information with a click of a button. So those kind of things, I feel, should also be governed by the institutions that must look after how these funds operate and how they administer and what's happening with the members' money. So I'm sorry, I'm very passionate about bargaining council funds. I feel it's unconstitutional to force people.
Taki, sorry, can I take this?
Yes, please do.
Linda, I think we need to take this offline. I think this is not the forum that we want to discuss, and trust the bargaining council funds. We hear this. The forum is here to discuss 13A and how we can resolve it. So if you've got problems with a specific bargaining council fund, please, you can contact either myself or Takalani and we can take it offline. If you do not get information from the funds and you're unhappy about the administration of that specific fund, we will gladly investigate your allegations. So for me, as a person who's been in the industry for yonks of years, an employer cannot say they don't know that the members should belong to a bargaining council because the members, there's a collective agreement and they negotiate, the bargaining council, the council negotiates salaries on behalf of those members that belongs to the council. So the employer should know. So that's something that I think if an employer pleads ignorance, I don't think they really, because in terms of the bargaining agreement, it's specific, you must belong or you have an option. So that's something that we can take offline as well. So I just wanted to say this is not the forum that we're here to discuss problems that you're having with bargaining council funds. We can address it offline. Thank you.
Linda, I think that
Wow.
we yeah. No, look, I think it's from Corlia's side and from ours, it's one thing to, you know, in the forum to say, you know, these people have this kind of problem. I don't know whether we can isolate some of those problems specifically only to bargaining councils, you know, so it is your experience of a particular bargaining council, and that's why I think when you're saying
it's not just one, it's all the bargaining councils in
Okay.
general, but I understand where you're coming from.
Yes,
Okay?
I think
It's not a
it
problem.
might be better for us to address it separately. And I can see some of the hands that have now come back are probably replies to you.
Hey, I'm in
so,
the dog box.
so I think we might need to just steer away from responses. I can see all of the bargaining councils are putting their hands up. Mr. Essop, Franklin, everybody. If your questions are related to engaging with Linda, please can we sort of see whether we can arrange some other way where we can communicate and see what things we can iron out. I want to say I apologize. You know, it's not the forum where we would have wanted to bring those kind of issues up as well. So if your question was in relation to that, please put your hand down. I'm asking, and then we will address Franklin. I think you're next. If it was in relation to her comments, please let us not address it in this forum.
Thank you, Madam.
Takalani,
Okay.
sorry to interrupt you, Franklin. Takalani, in the interest of time,
Yes.
can we maybe, I'm not sure if Penny is ready to present, maybe have her do her presentation, and then we will take down the names of Adam. I know Adam's hand has been up for a while. Yeah, okay, and the other hands that are coming up now,
Yes.
maybe take those after Penny's presentation, just in the interest of time.
Yeah. Penny, please, you can take over and share. We've known Penny for years. She is actually at the transport sector Provident Fund and is their legal advisor there, if I'm not mistaken. And they have gladly said they would like to share their experiences in terms of Section 13A. And we are very thankful for that. Thank you so much, Penny, and you can start your presentation.
Afternoon, Takalani, and afternoon, colleagues. And thank you so much for this time that you've given us to engage, to actually discuss what we've experienced. And being an old bargaining council fund, and as correctly pointed out by Linda, having changed from that, but we'll explain that structure. There we are. So what I'll go through this afternoon is the structure of the fund, how we're dealing with our 13A process. We're going to just look at historic non-compliant employer stats, and those often go back to a time when it was a bargaining council fund. Then what we're doing with our non-compliance complaints now at the Office of the Pension Fund Adjudicator. We've changed, I'm going to explain the change of process since the 1st of March this year, that we've decided to make a few changes to make our process more effective and proactive. Challenges that we've experienced, a lot of which have been raised this morning. Opportunities, because we're negative, but I do think that there are opportunities and we've got to grasp those opportunities and work with them. Some closing comments and then obviously questions. So the structure of the fund and the 13A process, we have got 2 administrators. So we've got a front office, very peculiar. So since I think from 2013, 2014, we've appointed 2 administrators, a front and a back office. We've got Sanlam Employee Benefits doing our front office administration, which focuses on contributions and fund level contributions. Then it goes to back office, the systems are integrated, and back office is SALT Employee Benefits. So the 2 functions work, the 2 front and back office, 2 administrators work very closely. Most of the work is done by front office, and we engage with the front office on the 13A process on a daily basis. And we found that that's the only way that we're making this process proactive. Otherwise, employers are not going to come to you, especially historically with employers that are used to the bargaining council and have raised problems very much like Linda has raised, to say they don't trust bargaining councils, all that, but you can change that perspective, that perception. So just with the 13A process, we follow it strictly. It's 100% automated. So letters go out and SMSs go out to members on the 30, 60 and 90 day, on those 90 days, at 30, 60 and 90 days. The 60 and 90 day FSCA reports go out every single month to the FSCA. Our fund is a little peculiar because our contributions get paid. We collect contributions through the bargaining council, not through the bargaining council. It's an historic bargaining council process. We get contributions in arrears by the 20th of the month after. And so our processes are a little different, yet we do report and we keep to these time periods. At 110 days, usually those reports prior to the 1st of March this year used to go to attorneys, and there are challenges, there's breakdown, you know, you don't have the same type of communications, your fingers aren't on the pulse, and also the costs of, it costs the fund. So at the moment, from the 1st of March, we tried an internal process where we've internalized. Our 110-day report comes into the fund, and we deal with them hands-on from the fund in the legal and risk department. So from the funds, when we first started it in March, I would refer the matter straight to the PFA, having employers presuming that employers took cognizance of the 30, 60, 90-day letters. But after about 3 months, I found that if we engage as the fund directly and we do another letter of demand specifically, including the responsible person, we've done a lot of work on that, and engaging with the employer, which means picking up the phone from the fund. And I think they got a shock that it wasn't an administrator or somebody, and that the fund actually stood up and said, okay, my friend, this is what we're doing. So we found a lot of engagement at that level. Once we don't get at that point, if we can't get the engagement and we don't get answers and the employer still ignores us, which they do, then we go to the PFA, probably at about 130, 140 days. And then at the same time, we refer to National Prosecuting Authority, SAPS, but there are challenges. Exactly what the challenges that are experienced in the industry, we've have experience with the SAPS. we're doing that process internally because the costs were exorbitant. Of every statement filed, it would cost a fortune. And we've got a large number of participating employers. I think at the moment we're on about 2,000. It ranges between 2,300 to 2,500 participating employers. So to do affidavits and criminal on our non-compliance, and those I'll explain the non-compliant ones. So it's costly. So our historic stats. So historically, and these are stats up to about the 30th of September from our front office administrator. So historically, we've got about 356 non-compliant employers. We've got 68 acknowledgements of debt, which present challenges as well. And often there's non-compliance on the acknowledgement of debt, and the process to follow up and enforce compliance on those. We're working on that because very often people default on that. So we've got 162 pension fund adjudicator determinations, which we execute. We send out warrants. We get a lot of retaliation from employers on the warrants, especially when we attaching immovable property or movable property that personally belongs to the responsible person. Our liquidated cases, we've got another 33. I'll talk about liquidation and business rescue because those do present a problem. We've got 2 business rescue cases. Generally, we've just managed to get probably a claim, I think that was in the region of about 8 million. Unfortunately, we only recovered about 880,000. So we're coming up with a process, and I'll explain what we're doing there. What we're going to do in those cases where we only get a portion of contributions back from liquidations and business rescues, it's a problem. And then in the process, a lot of our members who are bargaining council, who fall within the bargaining unit, a lot of those employers terminate at the bargaining council or exit the industry, but they don't tell us. So in the process, a year down the line, where we're doing 13A compliance, we're finding that they terminated a year ago and they just didn't tell us. So we do have, we're trying to sort out that problem, which is a problem between, a challenge between the bargaining council and us. Not a challenge, but there's a gap. So all in all, historical case, we've got 630 that are dealt with by attorneys. Rate of non-compliance is about 28%. And it is reducing. We're finding, and it's taking a lot of work between front office and the fund, but it's working. So at the end of September, we had 2,217 employers, of which 630 were non-compliant. The non-compliant employers prior, and these are non-compliant employers prior to the 1st of March 2020. So the challenges that we experience, so obviously at 110 days, it's reported to the fund. On those reports that we get, we actually manage them one by one. It takes a lot of work, but we manage and we deal with every employer that we get one by one. When we started at the beginning of March, I think the first month, we probably got about 30 reports. We're finding a lot of the non-compliant employers are perpetual non-compliant employers. So we focused on those ones, and we try to build up a relationship, because the relationship is not good at this stage. They're trying to avoid us, so we're trying to build up that trust. So we had, those were on 110 days, we had about 20 to 30. I think this month, the report that I got last week, we only got 4. And out of the 4, there's only 1 that's a perpetual one, which means that they're starting to make effort to comply. So as I've said, we're internally managing it from the 1st of March. We're finding it's a far more proactive and efficient process. We're not finding there's gaps. So as soon as we get the reports, we engage. We get an email from an employer or an attorney, we engage. We don't have to wait, but we're finding that as soon as we engage, we're building up those relationships, and that direct engagement with non-compliant employers gives us the opportunity to explain to them how important it is. I think somebody said in the process that a lot of employers, especially from bargaining councils, look at it as a grudge. Let's call it a grudge in like insurance. They don't understand, or they don't take cognizance of the fact it falls within, it's a part and parcel of our members' remuneration package. So we're trying to use those engagements to get the employers to understand. And the more we engage with them, the more, and they're engaging with us. They're phoning us and saying, listen, we've got this, how do you deal with this? Which is encouraging. And that we're finding that they are engaging with our front office far more as well, which is great news. What we're trying to do as well is reduce the number of settlements. So if somebody comes to me with a settlement, we don't accept, the fund doesn't accept settlements if they're over 6 months. We explain to them with regard to the risk that if there's an issue on the risk and a driver, and we have a lot of those, a lot of accidents, we have members that are disabled because of the nature of the work, because of the road accidents, they drive heavy trucks. Some of them get hijacked, they get hurt. So we say to them, if your risk isn't up to date, you're going to land up paying the 3 times annual salary or whatever you. So we're finding that they're trying to get compliant quicker. Also with the settlements, we're trying to avoid that. So if they come to the fund and say, we've got a settlement, we don't want to lose the employer, we don't want to lose employment. And I gently say to them, please remember the fund is not a bank. But let's try and find a way of resolving it specifically for the members. Our interests are in the members. It's our members that we focus on. Most employers who get the 30 and 60-day letters really comply within that time period. So by the time we get to 90 days, it's really those stubborn, non-compliant employers. As I've said, the current average is about 4 non-compliant employers at 110 days. And usually out of that, you'll find there's probably about 3 new ones that you can get compliant quickly, and 1 historic stubborn one that also has historic non-compliance, and where there are determinations for. A lot of them get 2-3 determinations at a time, or over a period of time. So at the moment, these are our stats just from the beginning of March. We got 60 initially in non-compliant employers on the 1st of March. 30 of those we refer to the Office of the PFA, Office of the Pension Fund Adjudicator. Those are the ones that we really have tried and they're not complying. 1 acknowledgement of debt has been signed. We're in the process of negotiating and discussing and working with about 14 different employers, which is good. We've got 9 determinations. And in those determinations, we are focusing very much when we do those referrals to the Office of the Pension Fund Adjudicator, we name responsible parties, directors, we name them all. And we emphasize in the complaint their personal responsibility. And we've got all their signatures, that they've signed acknowledgements that they're taking responsibility, and we're forcing that. We're finding that once we've done that, I think in the last year we're focusing on that. We're finding that the employers are far more amenable to sort this out if they know that they're personally responsible. And we're getting it early, so it's not as if we're getting them at the end where there's a 2 million rand, where it's a mountain where it can't be sorted. So we're getting it at a point where the outstanding contributions are maybe 140,000, which is not too bad for 1 employer. So we're finding that, as I said, liquidated cases and business rescue cases present challenge. What we have decided to do with those, and it's not something I know that has come to the PFA, and I have got quite a few opinions, but I do think that, and I think, trying to think, Tando actually mentioned it earlier. It doesn't, so even though the Companies Act has different rules regarding piercing a corporate veil as such, I think the PFA, I think it was Tando definitely that said earlier, the Pension Funds Act doesn't have, it doesn't say that you can't go for an individual or a responsible person. Even at the same time when the employer hasn't complied, you don't have to wait. And we're going to try and see if we, in business rescue cases where we haven't recovered the full contributions, we are going to try and lodge complaints against the responsible parties and directors in those incidents where there is a shortfall. Whether we'll be successful or not, we don't know. But I think it's worth our while. It's not going to, we're going to do it as an internal. And I think the focus, if we focus on those individuals that are responsible, much like Omar has emphasized, which I agree with Omar, if we put that pressure, we will find that the employer will comply. They start realizing they are personally responsible. So the challenges that we've experienced with 13A contributions, you know, our setup is a little different. We're not, as Linda also mentioned, the bargaining council for the road freight and transport industry and logistics industry doesn't prescribe that you belong to the transport sector anymore, or the road freight as we were called. The main agreement prescribes that you belong to a fund. So there are challenges with that because employers can fall through the cracks because we don't know if they belong to a fund, because they don't have to belong to us, but to transport sector. But that's a challenge that we've got. We've got challenges that are very peculiar to our fund, but interesting, and they have given us opportunities to find innovative ways. So obviously we've got a lot of movement of members between participating employers. They move from our members move from one company to another. A lot of them are employed by labour brokers, and they're contract workers across sectors. So you'll find that they work for 3 months, be it that they're in a sugar industry, they help with the transportation of sugar, then they won't work for 4 months. So it's difficult sometimes to see, especially if there's no contributions. There are challenges, as the industry knows, with foreign workers, and there's been a lot of pushback on the unions and local workers in the industry to stop foreign drivers working. So it's a problem that we face. It's a problem that a lot of our participating employers face. We also have problems with foreign drivers who have left the country and have not claimed and don't have South Africa, or they've lost their work permits, so their bank accounts are closed. So it's difficulties in paying them. So that's a problem that we're dealing with. As I said, a lot of employers, there are employers who deduct contributions and don't pay to the fund. There are employers who do not register. I think Linda picked that up as well. They do not register. They might be registered at the bargaining council, but they don't register with us. But because we're not a fund that you have to belong to through the bargaining council, we can't go, they can go to any other provident fund to get the membership. So a lot of employers do play that and might fall between the system. So those are the challenges that we have between the main agreement at the NBC and the transport sector rules. The one other problem that we do have is member schedules are not uploaded, and so we don't get member contact details. So it's all very well if we want to send out SMSs, but if an employer hasn't uploaded the member schedules to our front office, we don't have, and because of the movement of members between participating employers, we often don't have members' details that are updated. So, and members do change their numbers quite often. So when you send out SMSs, we get reports, and I think often we only get about 70%, 68, 70% of SMSs for non-compliant employers going to members. So often members don't know that they haven't, that their contributions haven't been paid. So that is a problem that we're constantly aware of, and we're trying to find a way of rectifying, and hopefully the new requirements on the conduct standard will help us get those in place. We're working on those. We're doing a workshop with our service providers, I think in January. We don't want to leave it longer to make sure our systems are aligned and to improve these type of gaps that we've found. Obviously, prescription time barring, because a lot of our members don't know that contributions are paid. So when they eventually do lay a complaint or where it is picked up, we've got the prescription and time barring issue. We've dealt with a few of those. I think the one case was referred to by Naheem. Then obviously the collection of LPI that we are battling with at the moment because of the induplum rule. So a lot of attorneys are coming back to us and saying, especially on the LPI that's been calculated on historically old contributions, the induplum rule is applicable, and those are one of the challenges. Business rescue and liquidations, where we don't get our full contributions, which, as I've said, the solution we are going to do now, going to implement, is to actually, even after the business rescue, now proceed against the individuals only, because we can't go against a liquidated employer. So we are going to proceed personally against responsible parties and or directors. Obviously, the same problems, criminal charges. So we do the criminal charges, but when we go to, because we're a national fund, so when we've got, and we're laying charges against an employer in the Western Cape, the SAPS say to us, now our principal officer must go down to the Western Cape to that police station to submit those charges and to lay charges. It's impossible. We have built up a relationship. We've engaged with the MPA personally ourselves, and we've got contacts. We've worked with police, people in the police. We've got a contact who tries to help us. So if there are challenges and pushback, we immediately SMS or WhatsApp him or email him, and he'll step in. But it's taken a while to build up that relationship with the SAPS as well. So opportunities. So I think Omar really emphasizes this wherever we are. Retirement funds are important. We're important for social security initiatives in the South African social structure. We've got to keep this in mind, and I lecture our employers about this. So the retirement funds, it is so important that the role that we play, we determine the living standard of millions of South Africans. We play a decisive role in the economy. We need to take responsibility. We also must remember that these contributions form the cornerstones of a lot of our members and people's retirement security. We cannot afford to be complacent now and wait 20 years for our current workforces to go and retire, and you can't expect them to live on, 3,000 or 4,000 Rand on a social grant. It is irresponsible of us not to be proactive and to try and mitigate these risks. And I think as a retirement fund, we are in a prime example to use this as an opportunity. We mustn't be negative about it. We need it as an opportunity. We need to encourage our employers, wherever we are, to take responsibility, as I said, for the employee well-being. If you've got an employee who knows that their risk is paid, that their retirement fund is paid, you will create your employee, your relationship with your employee is going to improve. And I emphasize this with a lot of our members of our employers. Obviously, and this is so important, the benefits that we provide as a fund, it's to members who often have no other access to life cover or other benefits. They do not have this type of access. They are in an emerging market. They're not financially literate. So we've got a responsibility as well to promote financial literacy of our members. We spend a lot, as our fund transport sector, we work a lot with our communications to increase literacy. We examined the financial literacy report. We studied it. We took it to board. We took it apart between us to see what we can do as a fund to address some of the problems that the FSCA has identified in that financial literacy report. We need to take that responsibility. If we make our members financially literate, it will help them understand and not only provide them with retirement, decent retirement in future, but it will also create that literacy that we need to encourage in our country. We need to. And that's the important part. That's an opportunity. And I think us as funds, as bargaining council, we ideally in that, or we're not a bargaining council, but bargaining councils and funds affiliated to bargaining councils have got a captive ordinance. Use it. So in closing, I think we need to be proactive, especially on the 13A process. We need to improve education and awareness, both of employers and members, regarding retirement funds, how they fit into the social, economic structure of South Africa, and also the responsibilities to ensure that contributions are paid. Don't let employers fall, that they become non-compliant for a year. And I know it does happen. We've got those. The sooner you're proactive, the sooner you see for on 90 days, 110 days, take the bull by the horns and engage with them. Take action against your 13A responsible persons and directors. Those are the persons that will make things happen. They will make a plan. Obviously, any engagement that we can get with SAPS to improve the criminal responsibility. You know, if you say to your directors or responsible, there's our statement. I've done a statement and the PO is going to report it to the police. So we need you to engage. Let me tell you, they jump up and they deal with it. They do not want to deal with criminal. I never explained to them that it is difficult and we have challenges, but I use it as a fulcrum, as a mechanism to encourage them. And obviously, I think in business rescue and liquidations, we also need to hold the responsible directors personally responsible. You'll never see directors and responsible parties coming out of a liquidation. Well, can't say never. Generally, you do not see your directors coming out of a liquidation and suffering. They'll be taken into another job. They don't lose their assets. That's different for our members and our members of retirement funds. So we need to also be much more proactive in liquidations and business rescues, and to also, and this is one thing that we worked on quite a lot as a fund, is to ensure that our contributions are not just taken as we're not taken as a concurrent creditor, that we actually put up there as a preferential creditor just below the secured creditors. We must be considered, those outstanding contributions in liquidations must be considered as preferential. It's part of our members' salary. I think that's all I've got to say after all of that. I do. Any questions?
Fantastic. Thank you so much. I haven't engaged with the transport sector retirement fund in a while. And it's certainly nice to see the progress and different things that you are applying now to try and better the situation. I don't know if there would have been any new hands, Penny, that would have come up for your particular presentation, but let's see, because we are at the end of the presentations from the speaker's side. So if there are any questions that are directed at you, then you will still be able to deal with them. We will now just go straight into finishing off in terms of our Q&A session for part 1. Remember, I really want to emphasize this, that we are doing this in a 3-part sort of series, and this is the first one. Next week, we will be doing another one, and we will be able to then send you the agenda for next week as well shortly, and then you can at least see what topics are coming up. And also, I think there was a question in the Q&A about whether the presentations will be made available. We are recording the presentations, or we are recording the sessions, so the presentations will be available to you on our website once we're done with the series. We have also put the presentations for the municipal webinar that we did on Section 13A, so you can see in what type of format those will be made available as well. I'm just going to go to Franklin Your hand is still up, so I'm assuming, from the previous questions that you might want to still ask something. Thank you.
Thank you, Madam Chair. Look, I've listened to the concerns that were raised pertaining to the prescription of debt. And fortunately, I've been previewed to judgments that deals with that. And the gentleman that made a presentation about the prescription, I don't think it will be fair for me to ask him a question other than to suggest that he should also look at the Mnyataza versus Johannesburg Metropolitan Bus Services case, which defined prescription versus to issues that had to do with Labor Relations Act matters. The reason why I'm raising that is because contributions at times, most of the time in the bargaining council I'm in, once somebody or company is in arrears and there is a compliance order issued, the company does not comply, such matter goes to arbitration. And a commissioner will then issue an award in that regard. In the case that I just made reference to, it was followed by a case of Mogoila versus Coca-Cola Fortune, where in that judgment, the court indicated that an arbitration award in favor of a particular employee would not prescribe, since the Prescription Act does not apply at all to Labor Relations Act matters. I'm saying this for the gentleman to make ref to go through those judgments, and so that we should, when we say prescription will apply on payment that was not effected, whether such an approach or decision will be correct, since there is a link between contribution and the Labor Relations Act. I'm saying there is a link on the basis that, bear in mind that the contributions that had to be made emanate from a collective agreement, which is also coined in the Labor Relations Act. We might be saying that the Prescription Act will apply only to find out it wouldn't, bearing in mind the decision that were taken in these judgments. Hence my plea to the gentleman to say, look, study those judgments and so that when we say Prescription Act will apply, such a decision should be informed, having had considered those judgments. Thank you.
No, thank you. Franklin, I think if you can just in the chat maybe put the name of the judgment you want me to look at, I'm happy to look at it and consider it.
Will do, thank you.
Thank you. Just Franklin, put it in the Q&A because the chat function has been disabled, so you can just put it there. And then I will go to Omar. Gary. Omar?
Thank you very much. I really enjoyed this. I didn't leave it 1 minute. And it's because of, like you, I'm not going to respond to that lady. I was so angry, Linda. But okay, let's have you. Let's get to I'm also on the issue of prescription. And the thing is, what our problem is that employers duck this 3 years very, very effectively through the bargaining council process and so on. And what we were thinking as a fund is to lobby you, to ask you if you can't get this 3 years for members' contribution extended. I don't know. I don't know what is the extension. You can speak to the various funds and see what is acceptable to us, and because I think the 3 years is a long time. I thought COVID 1 year is a long time. I thought 3 years is like a lifetime, but the 3 years is gone. We're out of COVID. So 3 years could sound like a long time, but once somebody wants to duck, he can take you to the Constitutional Court or wherever, and you will never get an answer until maybe after 5, 6 years. So please, can we look at looking at